For motion, item number 1.
Yes.
Where is Rosie? There, who is the engineer? My colleague is still requisition is praying for this one to invoke the right of habeas corpus. As he have been detained illegally. Well, he was under the custody. The respondent number 3 have passed the impunity decision order dated 27/3/2024. Which I annex as annexure 5 on page 28.
Okay, we'll issue notice at least. Heard that it comes into the petitioner. Anyone for the state? Your government advocate? PP here. And MS Swenso, PP for the state of Nagaland. Appearing on behalf of respondents 1, 2, 3 and learned CGC for respondent 4. This petition is filed seeking a writ of issuance of the habeas corpus for interference of the order dated 27 March 2024, issued by the Commissioner of Police and District Magistrate Dimapur, whereby the petitioner was detained under Section 3 of the NSA Act 1980. The said order also contains the grounds of detention. Stop. Learned counsel for the petitioner submits that this order has been illegally passed by the commissioner. And what are the grounds you're challenging this?
Section 12, subsection 1 is the complaint.
The conditions mentioned in section 12, subsection 1 of the NSA Act, read with Article 22(5), the Constitution of India, has not been complied with. Issue notice, returnable 2 weeks. Since the counsels for the respondents have already entered appearances, notices are waived. Our extra copies be furnished within a period of 3 working days. 3 working days from today. Let the respondents complete their instructions and apprise the court. Stop. They're permitted to file their necessary counter, if so advised in the meantime. List immediately after 2 weeks on a date to be fixed by the registry.
I have it.
For orders, item number 2.
Judgment. Where to listen again? 59.
So you read it. I want to work.
We did the 15
Well,
first.
You read the 15.
Writ petition is allowed. The impugn orders are set aside, and we further direct the detainee concerned in this petition shall be released forthwith if not required in connection with any other cases.
Well,
150.
we are passing similar orders in both the matters, both the items. Mr.
Same orders, 12 and
Same
15, 2 separate orders, but to the
Two
same.
separate orders, but conclusions are same. Both
That's what it is first.
Wait. Just one second.
Yes,
I bring to issue item number 5.
5.
Yes, Your Lordship.
Why?
I may be allowed to vote this under issue. Fine, average.
Okay. Anyone for the government? At the request of learned counsel for the petitioner, who submits that he has instructions to withdraw the writ petition, the prayer made is allowed. The writ petition stands dismissed on withdrawal with liberty. MS so appears for the government, state of Nagaland. Yes,
Your Lordship, I also take the mention hearing item 24.
24.
Your Lordship, kindly pass this matter for today. Pass over.
Item 24, at the request of counsel for the petitioner, matter stands passed over for the day. Prayer made is not objected to by the State Council.
Please proceed. My lord, I bet many I can bring the hearing. My colleague who is helping assisting me in this our station. So may I have taken the consent of the opening. May I present this matter in this.
You're for the petitioner,
No, for the respondent number 5.
respondent 5. Item 20 is a fixed matter.
My lord,
Yes, what do you say?
No objection. You have to wait then.
All right. Item 20 at the request of Mr.
Yes, no.
Azo, Learned Counsel appearing for
Respondent number 5.
respondent number 5, who prays for adjournment for this week, stands deferred. Stop. Counsel for the petitioner does not object to the prayer made. List after a week.
Interim will continue.
Interim order passed earlier will continue until further orders. Yes.
Yeah, please, Your Worship.
Yes.
Your Worship, I take permission, I don't know bit of.
Well-
My seniors in this book, so it can never become about the few weeks.
Your senior is
Is in this post.
indisposed. Who's your senior?
Is continued.
Okay, mention is made on behalf of Mr. S. Temjan. And it is submitted that the learned counsel for the petitioner is indisposed. Prayer is made for adjournment for seeking adjournment to have the matter listed after 3 weeks. Prayer made is not objected to by the counsel for the state. List after 3 weeks as prayed for.
Yeah, Mr. Rashid. Rashid, I recommend item 21. Rashid. And
21.
whoever be done, with this matter to be possible to be done.
Who's for the petitioner? Anyone for the petitioner? Yes, Mr. Jamir. The other side is mentioning your matter. Item 21. No objection? It's the request of council, state council. Matter stands passed over for the day. Mr. City Jamir, Senior Counsel, assisted by Mr. So-and-so, appears for the petitioner. Yes.
Yeah, Mr. Rashid. Rashid, I recommend item 22. Rashid. With this matter can be listed next week.
You give me your list. How many matters you want to mention? We'll adjourn, we'll allow all your prayers. Yes, item 22 at the request of government council stands deferred. We listed after
A week.
1 week, yes. Interim order passed earlier will continue.
Rashid, I recommend you to do the executive.
Yes.
Matter from any grant, listen at that level.
You're for the petitioner?
Listen.
Any objection?
I'll go.
Item 28, 29, 30 at the request of learned counsel to the petitioner stands adjourned. We listed after 1 week.
Mr. Rashid. Item 4. I can bring me 1 week to file my affidavit in the grant.
Item 4,
Yes, sir.
at the request of counsel for the petitioner, matter stands adjourned. We listed after 3 weeks.
1 week.
1 week, 1 week, enabling her to file the affidavit in reply
The affidavit in opposition by the respondent 1 to 3.
to the affidavit in opposition filed by respondents 1, 2, and 3. Prayer made is not objected to by the counsel for the respondents. List accordingly. Yes,
I recommend item 25 from the hearing list. Your Lordship.
25,
Yes.
yes.
Your Lordship, you can plans better date, this after 3 weeks, Your Lordship.
You're for the petitioner,
State, Your Lordship.
state. Any objections from the petitioner? Who's for the petitioner?
The petitioner this morning.
All right, we are passing an order subject to concurrence, consent of the petitioner. You obtain a consent? You call up the petitioner and inform them that you are mentioning the matter. Request is made on behalf of the government council seeking an adjournment for 2 weeks, 3 weeks. Stop. None appears for the petitioner. Matter stands adjourned to be listed after 3 weeks. Yes.
On this item, this one. The matter tomorrow, I have instructions to be followed.
All right. List tomorrow.
Let's.
13. Yes.
On the last occasion, I have sort of tried to find a reasonable activity. After the reports. That is, we may not be necessary. That whether company is. And we need a. This more.
We can take it up. We can take it up for admission also
We should up the rules of.
after 2 weeks, not today. All right, item 13 at the request of Learned Council for CGC. A joint request, matter is adjourned to be listed for admission after 2 weeks. Yes.
Special. I'd like to mention item number 11.
11.
The motion hearing meetings are completed. It can be fixed for hearing on 5th of December in Russia.
5th of December, all right, item 11 at the request of council for petitioner. Matter be listed for hearing. Then we have to issue rule, it's an admission, we have to issue rule. Or you want a hearing in the admission?
The hearing to be substituted for information.
File. Give me the file. Item 11. Is it 11? You write item 11, since it is submitted at the bar, the pleadings are completed. Let rule be issued. Matter be listed. On 5th of December, as agreed to by both councils for hearing.
Question I've been doing, I'm number 1818. Which here I am yet to receive the instruction.
Anyone for the petitioner? Anyone for the petitioner?
Number 18.
Item 18, anyone? No, no one for the petitioner. You have taken consent.
Question here, I have not yet received the instruction.
Right, Learned, you are for the government. Government,
Respond.
state council for the state respondents. 6 further 2 weeks time,
3 weeks.
3 weeks time. To complete his instructions and file necessary counter in the matter. Let the matter be listed accordingly. After 3 weeks. You inform the council for the petition. The council, the government advocate undertakes to inform the council for the petition. Yes.
Let's go into December item 23. On behalf of Sor Ali Singh. I think also for the petitioner. The matter began with the state on 25th November, since he is an all-state mayor.
25th November.
This one.
Item 23, prayer is made on behalf of the council for the petitioner to have the matter listed for hearing on 25th of November. Prayer made is not objected to by the council for the respondent, list accordingly on 25th of November. Yes, yes.
Worship, item number 6.
Yes.
On behalf of my seniors in the worship. Can you grant us 3 weeks time to file a in the package?
Item 6, at the request of counsel for petitioner, be referred to be listed after 3 weeks, enabling them to file the affidavit in reply. Yes,
Lordship, I also like to mention item 16.
yes.
Lordship, can you grant us 1 week time to file affidavit in reply?
Item 16, one to be listed after 1 week, enabling them to file affidavit in reply. List accordingly.
For motion, item number 1 and 2.
Yes,
Please, your lordship. In this instant, there's an error, so I may be allowed to withdraw this. I with the liberty to file afresh.
you want to withdraw the IA.
Yes, there's an error in the post statute.
You file an IA to correct the petition, and then there is a further error in the IA.
Your lordship.
At the request of learned counsel, who submits that there are some errors, unintended errors, which are seen in the pleadings, and therefore she seeks liberty to withdraw this IA and file afresh. Prayer is not objected to by the learned counsel,
I'm appearing on behalf of the state government,
uh,
special counsel.
uh,
1, 2, 3.
by Mr. ESO as special counsel appearing on behalf of the state. Prayer made is allowed. IA stands dismissed on withdrawal with liberty.
Which
Yes.
lodge?
Item number 3.
Please, your lordship. Your lordship, here the petitioner is challenging the Indian appointment order. March 2024 and July 2024, your lordship. Your lordship, here the
Page number? Page,
page number 10, your lordship.
page number
Your
10.
lordship, page 18.
Yes,
This is the appointment of the lordship.
yes.
Your lordship, here the petitioner is one of the applicant who was duly recommended by the landowner for the post of medical attendant at Songdo village under Buka district. Now, your lordship, here during the year 1974, the landowner had donated a plot of land for the establishment of primary health center in Buka. Accordingly, on the instruction of the respondent, they have exhibited an equipment lordship you can see at page 14A, type copy lordship.
14A,
Is lordship.
yes,
It's serial number 2. I think
yes.
you are allowed to read lordship. To offer any grade of government job that the landowners according to the availability of course, if any, and when credit for. So passing on this, the petitioner has duly recommended by the landowner for the post of medical attendant. Now, lordship only learn about that vacant post at been arose in the primary health center. The petitioner had made an application. However, without considering the case of the petitioner on the basis of land ownership, the state respondent has appointed the private respondent number 6 lordship. So lordship, subsequent to the appointment of the respondent number 6, the petitioner had also made a representation before the concerned department lordship. Lordship may kindly see an annexure 5 space, page number 20 lordship. The petitioner through the landowner had made a representation which the state respondent have orderly agreed to consider the case of the petitioner. However, till no action had been made, so being with the petitioners bring before this one of the board.
All right, we'll issue notice at this stage. Heard when it comes up to the petitioner. It is submitted that the petitioner had donated a plot of land for construction of primary health center at Sungro village, Wokha, in the state of Nagaland. Stop. She came to be aware that there's one grade 4 post for medical attendant which was lying vacant. And accordingly, on a recommendation by the landowner, petitioner applied. Stop. The petitioner did not donate, it was Chipasau Nguli who donated, right? First line. Stop. In spite of assurances given by the state, subsequently, the private respondent number 6 came to be appointed as in the post of medical attendant in Sungro, PHC, Wokha, Nagaland. So, being agreed, present writ petition has been filed. It is submitted that there is an agreement between the landowner and the government, which reflects, which describes the land which was donated for establishment of the PHC. Stop. As per the policy of the government, landowners or their family members are entitled to be considered for grade 4 posts in the establishments to which the land was donated by the landowner. Stop. Para. Let notice issue, returnable 3 weeks. MS so-and-so appears for the state 1, 2, 3, 4, 5. Stop. Notices therefore are waived. However, extra copies be furnished within 1 week from today. Steps on respondent 6 by usual course and registered post within 1 week from today. Matter be listed after. What interim? Huh? How does it benefit you? She's already appointed, he or she? He is already appointed. So you suspend the order, you can't get into the job. Right. Interim prayers, if any, will be considered after returnable date.
For admission, item number 7.
Some reply affidavit was to be filed.
Yes, complete everything.
All right, then. Okay.
This is the candidate amendment of Madam Disposal.
Today. In try. You are for the petitioner. Who's filed the IA?
I filed the IA, but instead of considering the IA, that is for modification of the interim order.
Might as well hear the matter.
To go for a straight hearing.
Right.
Because the urgency is involved and on the strength of the interim order. The petitioner is illegally occupying the landlord.
All right. Yes.
The gist of the matter. The case of the petition is that the revenue respondent will increase the settlement cum revenue officer to the office of the deputy commissioner. But in appeal order, he has decided the ownership, the title over a property in favor of the respondent number 4 and against the petitioner. My case is that, my lord, exercising revenue jurisdiction, it does not have such force. It's not competent to decide ownership. Lordship, this dispute can only be decided with competency. That is my case. The state respondent has come along in the affidavit. In the appeal order, it is not there, but in the affidavit, they said that this is an order which this will only be possession. And it has been passed under section 145 CRPC. Lordship, there are certain requirements under section 145 CRPC. Those are not there. Lordship, he has also, those requirement has not been fulfilled. This order of this 145 can only be passed to prevent breach of peace. And that also must show. So my lord, my case also is that their affidavit, the imprint order can be judged by the contents of the order itself, and the affidavit cannot come and better impugnate. So that, now, lordship may, if I may take the lordship to the taxable.
Take us to the order first, the impugned order.
Well, page 22.
Yes.
It is dated, 11 by this, 26, on page 26, the date is given, that is 11 by this 323.
Yes,
And it from page 23 onwards,
yes,
in the matter of such and such, Mr. Chapi Nayak is the respondent number 4, my lord. Is
Yes.
representing respondent number 4.
yes.
And only to show, hey, my lord, it's appearing here, it's appearing here through his petition, attorney holder. So whereas the repetition sorry, whereas a written complaint dated 10/10/2022 was received from C. Chabi Nayak and 3 others. I can see Akuru Ashwini or attorney holder of C. Monito Shebe about land encroachment and illegal construction of a house within the compound of National Spiritual Assembly of Baha'is of India under Pata number 8 Pata number such, area 1 Bida 3 Kata 2 Leches, block number 9, Novo Moza number 2. The complaint stated that on 3rd October 2022, at around 8 AM, some unknown person blocked the main gate of the institution and started illegal construction within the compound of the office of institution. On being approached to stop the construction works by the representative of the National Spiritual Assembly of Baha'is of India, the encourager did not stop the construction. Hence, the representative National Spiritual Assembly of Baha'is of India has filed this complaint against the illegal encroachment and illegal construction within the office of land. Verification of the site was conducted by head GP in Mapur. It was reported that the thatched house has been constructed within the compound of the National Spiritual Assembly of Baha'is of India by Sri Akharu Ashwini. It was further stated that the said site of attached house temporary GI with bamboo neck wall house of 13 into 30 feet dimension was constructed by Akharu Ashwini. Photograph of the house already available. Subsequently, a restraining order by number such dated 28/11/22 was issued to Sri Akharu Ashwini, attorney holder of Manito Shahid, and both parties were summoned on 5/12/2023. It is submissions, this is filed by the court, e-counsel, taken on file. Succession hearing was conducted on 5/12/2022, 26 and 16/5/2023. When counsel for the petitioners, Nabi Nayak and few others submits that the land was purchased by National Spiritual Assembly of Baha'is India by 7 such dated 9/1/1988. Executed at Dimapur on the 2nd day of December 1997. It is written purely under me and the National Spiritual Baha'is of India, signed by Sri E.R. Panda on behalf of the National Spiritual Assembly of Baha'is of India. Thereafter, mutation for Pata number such, that number such, block number such, situated at K such colony belonging to him, particularly under me, was granted by federal mutation getting such. That is such. Subsequently, Pata number 818 was issued to the name of National Spiritual Assembly of Baha'is of India under that number such area number such. Block number 9, Babu Moza 2, consequently, boundary walls, bricks and iron gate was constructed. The institution has also conducted various activities, programs from time to time. All documents of cell mutation Pata was received. Submission was also made by Sri Chabi Nayak, representative of National Spiritual Assembly of India, who stated that the land is under occupation of the institution for 32 years without any disturbance until the present case arose on 3/10/2022. When the respondent even broke the main gate of the institution and started illegal construction within the compound of the institution. It was further submitted that there was no person as Sri Manito Sohe or Bori or of attorney for the streets. Akharu Ashwini has appeared for 32 years within the land of National Spiritual Assembly of Baha'is of India. Per contra, Sriakal Ocean or Botany Holder, Panital Shohi, in his written statement submitted that the land was occupied and he had done general clearing and cutting of trees and had been consecutively applied for regularization since 92-93, but unfortunately, government has banned issue of pata and he was unable to obtain the land pata. Copies of ban on government land allotment issued by the state government that is such were also furnished. When he visited the seven in the month of November 2008, some unidentified person had constructed a wall around it, for which he inferred in the revenue office for possession of the land pata, but he could not find any legal documents pertaining to it. Thereafter, he has obtained Jamawati on 8/3/2010, and since then, he has logged the bill and has been paying revenue tax till date. He further submitted that there was no dispute claim of the land for the last 12 years of blocking the bill. Leonard's counsel for Sriakal Ocean or attorney holder of Sriakal Ocean submits that the claim of the complainant that they had purchased the land in question in the year 1997 from Secretary and Commissioner in as much as during the period from 92 to 98, there were various government memorandums and notification banning the allotment of land to private individuals. And by reason of the same, monitor showing did not regularize the land in question into his state. Further, it was submitted that the acquisition of the land by the aforementioned person or organization and the owners evidencing the transaction has been effected in contravention of the provision of subsection 2 of section 163 of the Nagaland Land and Revenue Regulation Act 1978 and level making transaction with application. Several issues were raised by both the parties. However, this court has dwelled into the issues pertaining to revenue matters. It is submission furnished documents, of arguments, and office records were fully produced. And personal relevant revenue records. It was observed that the disputed land was originally standing in the name of Chekri and company who was regularized allotted the land in the year 1990, measuring 15 because 1 cut of 19 lectures under that number such as such. Order number such, white order number such dated 4/6/1990. Order number 442 was accordingly issued to Chekri and company. In the year 1998, invitation case of research was registered in the part of the National Commission for an area of such as such from part number 422, block number 9, model number 3, that case such a colony was standing in the name of the company, so under Rule 51 of the Assam Land Revenue Regulation Act 1986. The mandatory public notice was issued. A survey was executed and duly registered before the sub-registered registration of such dated 9/1/19 between Chekri and the National Spiritual Assembly of Baha'is. According to the land was treated and separated for part of the 442 in favor of National Spiritual Assembly of Baha'is of India when notification of such dated 9/6/19. The pattern number 1683, that number 19.145, measuring an area of 1 meter, 3 katas. 0 lectures, studying in the name of Sri Kohima furnished by the respondent was recorded to be allotted by number such, dated 8/3/2010. The record of the file of the allotment number such could not be placed in the revenue branch. Also, the issue number of the allotment order number such, dated 8/3/2010 is not found. Recorded in the issue register, maintained for letters, orders issued by the office. It's also observed that the proposed allotment of the land measuring 1 meter 3 10 lectures issued to say to show falls within the compound of National Spiritual Assembly of Baha'is, which is fenced by pre-war. The BLC land record is survey of this. This verification report for pattern number such, standing in the name of National Spiritual Assembly of Baha'is of India states that non possession found telling impact revenue records. This plot of land is outside ROW. The survey report further states that, however, except for the one.
What is ROW?
Right
away. All right.
Except for the number 1683 in respect of Sri Panital Shohi, the soil found in resettlement that the land revenue department, government of Nagaland is issued a notification that it such dated 26 October 1992, then allotment of land to private individuals social service. On examining the allotment order produced by the respondent, it is observed that the allotment was issued without the approval of the government when the burn order was still in force, rendering it to be liable for cancellation. After considering the above facts and findings, I'm of the opinion that the cell mutation order, PACA of the complainant are executed and issued as per prescribed procedures. Number two, the location of the PACA produced by the complainant is tallying with the records. Three, the allotment order produced by the respondent is not in the revenue records, and the allotment order issued number is not recorded in the issue register, indicating that the order allotment is not issued by competent authority. Further, the allotment order produced by the respondent is issued without approval of the government, while the allotment grant order is in force. The allotment order in total does not conform with the standing order issued by the government, and land allotment is therefore liable to be cancelled. On the basis of illegal allotment order and PACA, the respondent is occupying the land belonging to National Spiritual Assembly of Baha'is of India, which needs to be vacated and handed over to the National Spiritual Assembly of India, Baha'is of India. The constructed culture house has come up within the compound of the land under National Spiritual Assembly of Baha'is of India, Pakistan.
Yes.
In view of the above, C-22 and its authority policy approach are found to have been illegal possession. And as forcefully and wrongfully disposes the National Spiritual Assembly of Baha'is under the such museum from the Karachi as Therefore, it is declared that the National Spiritual Assembly of Baha'is of India is entitled to possession of the aforementioned land until elected, therefore, in due course of law, and for taking all the service of such possession until such demolition. Further, C-22 is directed to dismantle the culture post constructed by its attorney policy of Lordship, as the same is within the compound of National Spiritual Assembly of Baha'is. Vacate the premises, hand over the land to National Spiritual Assembly of Baha'is. C-22 Sohail's attorney policy of shall hand over the said land in possible possession of National Spiritual Assembly of Baha'is of India, free from all encumbrances within 14 days from the date of receipt of this order. In the meantime, this office shall proceed for cancellation of allotment order issued to Sri Manindra before the completion. So therefore, Lordship this will show that he says he is categorically, Lordship may come once more, my lord, below. It is passed by the revenue comes settlement officer. So, my lord, he has exercised his jurisdiction as a revenue officer. He's also mentioned in the revenue order itself that I'm only concerned with revenue matters. So, therefore, my lord, this order apparently just having a look at where bad glance itself shows that it's passed on the revenue side. Now, my lord, he has said that my PACA is not there in the records. The allotment order given to me is not there in the records, so he's basically saying that these are not genuine documents. And his PACA, that's rule number 4 PACA, is there in the records. Therefore, the land belongs to him, and therefore I must hand and have encroached the land. Now, my appropriation is I'm treated as an encroacher. The trespasser and I should be evicted. So therefore, I've been directed to hand over possession within a specific period, and not only that portion. Not only that, he is also further directed the PACA, the allotment. Should in my favor, whether in 2010 should be cancelled. Proceed, the office should proceed for cancellation of that. So this is so therefore, Lordship, he has also touched on the merit of the case. He has also dealt with my right interest and title over the land. And he has he's also asked me to ask the authorities to dismantle. He has also directed for dismantling the house built there. The family residing there. That's it. My ground, can the revenue authority, when it comes to a dispute regarding the ownership of a property, can he pass such a order? Does he have the competence to do so?
So first tell us, where is your complaint petition? Where is it?
Lordship, the complaint was made by him.
By the
By the respondent.
respondent.
He went to the deputy commissioner.
Complaint was by both the parties.
No, subsequently, I got there.
Oh.
First he went. So now, Lordship, I just
Where is that complaint?
complained by him. Lordship, the complaint was to us, I mean, the complaint was not furnished to us before the revenue service. Before, what?
Is it at page 54?
Chief, in our affidavit in opposition, my complaint is at page 46, and the complaint by the attorney holder is at page 49. In affidavit in opposition of respondent number 4. Put the complaints are there, and on the basis of put the complaints, the revenue commissioner officer has taken a decision.
What happened, Mama?
No.
When they filed a complaint, a copy was not furnished to me, either by the complainant, nor by the revenue officer. I also filed a complaint, counter complaint, saying that these people are trying to. Before this also, they went to the Statute Colony Council, which is not a statutory body. And the Statute Colony Council said, we don't have the jurisdiction, we could approach the revenue authorities. So when they approached the revenue authorities, we were someone, a restraining order was passed, Lordship. That is at page, Lordship may also page. Lordship may kindly come to page 46.
46 of?
My lead petition now.
Okay. Yes.
So the respondent for the representative of respondent for approached the deputy commissioner. And the revenue settlement officer, the same officer, passed this order on 20th November 2022. Whereas this office is in receipt of a complaint from C. Chapi Nayak, representative of National Spiritual Assembly of Gauhati, India, to the effect that Sri Hanitu Shohei has illegally encroached and constructed a house within the compound of National Spiritual Assembly of Gauhati, India, under Patron number such, situated at Kesachi colony. Accordingly, a direction was issued to the head DP and DP by order number such, 31/10/2022, to verify, identify the alleged encroachment. Consequently, the report has been submitted to the effect that H house measuring such has been illegally constructed by Akolo Oshimi within the compound. Such Akolo Oshimi is hereby restricted from carrying out any further construction on the development activities till the matters settled by this office. In the meantime, Akolo Oshimi, the National Special Assembly Gauhati, India, directed to appear before his office on 5/12/2023 for hearing of the case. The parties also directed to produce information friendly at the time of hearing. So this was possible. This is the only order possible before you think about that. And after this, we appear portion. The complaint, they have already filed a complaint. This complaint we have not received unless till we got it, we have seen it only in the affidavit. Then we also filed a counter complaint. Then we also received the cheese of arguments supplied by them. We also submitted cheese of arguments, also produced documents. Our case has been rejected, saying that these are fabricated, not genuine documents. Their case has been accepted, and the matter has been decided in that time. So, my lord, my case is better. You can do that. You can do that only if it's just jurisdiction, my lord. Who is it? So that is what this basically. Now, what has happened, my lord? If I may, what should I have stated in my petition? May I just briefly? Okay.
His prayer is at page 47
Yes,
of the affidavit in opposition.
page 47. Yes, Lordship.
Page 47.
Lordship.
This is for land encroachment and illegal construction.
Yes,
Should be stopped. And evict illegal occupation.
yes.
Now, are you saying the revenue authorities have no power to do that?
No, because there's a dispute regarding that. Punish. Because I'm the owner of the land. How can I just be evicted unless
Where are your documents for ownership?
Yes. How can I be evicted unless my title over the land is proved? Decided first. Lordship, Lordship, before that, just before I take my lordship to my documents, I'll just take 2 minutes. In 1999, this is in the moment. Entire was nearby there was
Entire area was?
jungle. Nearby there was again border road organization here. Lordship, I am from Zanamur. The pata holder is from Zanamur. Lordship, I came to Dimapur and I cleared the jungle and the woods that from there I supplied it to Assam Rifle. Yeah, that third mile. Thereafter, since 1990, I've been in operation. Lordship, I have
This land belongs to whom?
belongs to the government. Nobody's land. at the moment. Therefore, what I did, after clearance with the zone, I applied for settlement of the land matter on the basis of my application. I have made altogether 3 applications. All these 3 applications were not, they're not allowed because at that point of time there was a ban for allotment of land. Unless this is approved by the government. That's what it was. I was also showing that I also annexed on the was given to me the standing memorandum at that point of time, denying the regularization. That also happened next year. And then in 1994, I left for zona voting. I kept a caretaker on Monday to take care of this. What he did, he cultivated the area on vegetable cultivation. Then I left for zona voting. Then at that point of time, Malak Dimapur was not a district, it was only a subdivision. So all this have been addressed to the ADC. In 1997, Dimapur became a food district. I returned, I pursued the matter again, but that was in 1997. Then
Pursued for what?
for settlement,
Settlement in your favor.
no. Because, and I also have also said that, please, since this is an order, unless there's a government approval, allotment cannot be made to me. I've also requested in my application that please forward the matter for approval to the government in my application at that point of time. And then Lordship, what has happened? I left again. Again, the caretaker was in charge of this place. In 2008, I learned that my caretaker, Mr. Pandey, was chased away. So I returned. I found the wall, I found the place being brick, the brick wall, fenced by brick wall. I also found an R&D, but I did not find anybody occupying the place. So what I did, I locked the gate. I locked the gate with my lock. Then I pursued for my settlement of the land, regularization of the land. And in 2010, an allotment was made. And pursuant to the allotment, I was given power. And I've been paying land revenue taxes regularly since then. The land was under my occupation system. But Lordship, I am a person with some financial difficulties and also now not well. So the land was kept vacant. In 2022, I allowed this person, who's my power of attorney holder, to stay there. He needed a place, so I allowed him to stay there.
While allotting the land in your favor, was there no physical verification of the land, measurement of the land?
I must have done my.
So if the area is
No.
covered by a brick wall,
But that is the case. I have this here now. So therefore, that was that how it was done, that I cannot say. Well, now in 2022, sometime in the middle of the year, sometime in June, July, my power of attorney holder, Peter Catch Station, I started residing there with his family. That's when, in October, the respondent of the court came and said that this is my land, the encroach my land, and the complaint started.
but your caretaker, while he was there, how did he stay on the land? He must have built some shelter.
Lordship, he was farming, he was cultivating the.
No, but where was he
I don't
staying?
know where he was staying, but he had a farm there, vegetable farm. Now, Lordship, I kindly come to my promise there. Lordship,
No,
these are the things.
All right, facts will go. You show us the grounds of your challenge,
Yes,
your challenge of this order.
This is not, Lordship, that way is raised by me and also objection raised by the other side. These are related to facts, which can be decided only through evidence, which is therefore a civil court.
No, that is okay. Now the question is, who's going to approach the civil court?
Who is to approach the civil court? My lord, I am in possession. Therefore, the person who is involved, who wants to evict me from that place, who's agreed.
But that was contrary to your own submissions, that this place was bounded with a wall,
Well, back in 2008, my lord.
and which you did not erect this boundary wall.
No, 2008, my lord.
So somebody was in possession.
If somebody comes and builds a brick wall or builds a wall, my lord, while I'm away, doesn't mean that he becomes the owner.
No. This again becomes a disputed question.
So from 2008, since the day they raised the dispute in 2022, I was in occupation. More than 12 years, my lord, 2008 till 22. Even if I did not have the title, my lord, because of my long years of occupation, law of possession, I have the right over the land.
Yes. But what do you say regarding the finding of the DC? That
Revenue officer.
revenue officer, that the records are not available.
That is something that also has to be decided. I'm saying no. I was properly generally given to me. Prove it, my lord. Prove it in the civil court that these are fact news. Prove it, my lord. Like, it cannot be just a decision and say, oh, these are not there. How do I know it's there, not there?
It is for you to pursue that matter and get
Then-
the
Therefore,
record.
by till then, since I'm the one who's in possession, why should my possession be disturbed? Can be only disturbed in accordance with law, and therefore that possession can be disturbed only under section 145 portion. That's what they're saying. The government is saying, government has come, yes, agree, yes, in a revenue proceeding, I cannot decide that. And I have not decided that, that's what they're saying, Madam. But we have passed this order under section 145, specific affidavit release. Now, first of all, we have to see whether this is an order, because they're saying if it's passed on the revenue side, my lord, they don't have jurisdiction to do so. They agree. But this was not passed on the revenue side, this was passed under section 145 CRPC. And we are dealing only with possession. Now, my lord, we have to see whether this is an order passed under 145. Lordship, but can I show my lordship the first in my documents, my lord? It'll just take 2 minutes. Just to, lordship, my kindly come to me. Lordship, page 29. Lordship, I not read this. These are the notification at the time no allotment should be given. No allotment should be made.
Yes.
This is page 29, my lord. No allotment should be made. Lordship, my lord, safety.
29.
Page 29, 15 September 1992. Government has decided that in view of many government works project buildings have to be undertaken or settled in the limited area, that is required, no government then will be allowed to any individual. As such, all DC, ADC, SDOs are received from making a recommendation for allotment to the government. All concerned are requested to ensure compliance, knowledge, receipt of this memorandum, this order makes immediate effect. Page 30 is the back copy, 31 is the another similar order notification. And
Yes.
31. This is dated 26th October 92. The government has decided to ban the allotment of land to any individuals for this areas in another further orders. All deputy commissioner, additional deputy commissioner, sub-divisional officers are therefore directed not to the government for allotment of the land to the government. Till council are requested to ensure for compliance, this will take immediate effect. So, my lord, there's a plan not to allow, direction not to allow the allowance. Now, lordship, page 33. This is the application, my lord, made in the year 1993. I have that copy also, but let me read from the original, my lord. To the additional deputy commissioner, Dimapur, previous letter dated 2011-92. Where for regularization of vested land in the name of the purpose for farming and cultivation. With due respect and honor, I would like to say few words of favor for your kind consideration. Sir, the land behind GREF of this camp between a small stream where I have done some jungle clearing and planting trees for supply of firewood of the Indian Army in a barren land which is completely outside the camp and is government land. Since I have no land in Dimapur to sustain my living farm and cultivate, so I have been trying to regulate my cultivation land at your office in Serman. But at that time, the government has banned the allotment for regularization of the same land. Why don't know they such and there is such? I therefore kindly request your authority to regularize my jungle clearing, cutting land once the ban order has been lifted, so that I can sustain my livelihood. And my lord, similar application of page 35, my lord, page 36 is the that copy, my lord. Later they did such and such, pray for issues of Maka, absolutely. I have the honor to state a few words for your favor of your kind action. Yes, sir, I've been watching your office for my land organizations since 1992, but the government has continuously banned issue land allotment to individuals, organizations. Although it is land and reliable sources, that some of my neighboring areas has brought land patas, but when I approach your office, the staff from land revenue assistant issued me one government memorandum that is such, 8 July 98, and the best need to get approval from the government level. It's therefore, I earnestly request your authority to kindly forward my petition to the government for approval and then the session. Lordship, this was done in 1999, after the Kohima becomes a district. And Lordship, page 37 is the allotment order. Lordship, here is without government approval, we should not give allotment, that is the order on page 37. Then Lordship, may kindly come to page 39, my lord. This is the order of allotment, dated 8/3/2020. The plot of land under the part of that number 19 measuring area of the achieved industry. That block number 9 is hereby regularized in the name of Sri but land is regularized if I have the opposition. Therefore, the survey revenue record branch is hereby directed to issue Jamabandi. Then motion may kindly come to the Patna, Jamab. This is the Jamabandi, this is the Patna used in Nagaland before. Now we have the Patna book system before this was in Nagaland. The Jamabandi, Patna number 1683, the process name Mala, and that number is given. Measuring Mala area 1 meter 3 meters. And remark regularized by order number such dated 8/3/2010. And then page 41 are the payment of revenue received. Revenue has been cleared up to the year 2022. Page 41. Then page 43 also Mala. Received whereby in 25/8/2022, Office of the Deputy Commissioner, page 43. 25/8/2022. While I was engaged in all this, my and non-encumbrance certificate was issued in my favor. Now, Lordship, my plan is then page 44, 45 are this is the way my power of attorney holder and his family were residing in this place. This is the place for them. See, my whole family have been residing there. So therefore, Lordship, may not just sit away to the grounds of service.
First, let us see what the government has to say.
Yes. Academic opposition on behalf of the Supreme Court Lordship,
The routine order was passed this of the what's
But where is your affidavit? There is one affidavit in reply to the affidavit in opposition. Then one affidavit in reply again by petitioner against this, then additional affidavit in opposition.
in opposition.
Okay, filed on 16 February, okay. Yes. Yes. What do you say regarding the contentions of the petitioner?
Was passed based on the reports and legal lordship. Here the petitioner claims that the state of land is. Claims the state of land based on the regularization of the 8/3/2010. When this order was passed, when there was a ban on the allotment of land.
Then why did the DC issue the settlement if there was a ban?
It's not, the reports were not available on verification.
So what steps the DC has taken? I mean,
Mentioned in my affidavit that on verification, the issue, of the issue register maintained by the respondents was found that.
page number?
Page number 4.
Oh,
Paragraph 9.
yes.
On verification of the issue register maintained by the answering respondent of this, the serial number 11212 does not find mention on this particular date, that is 8/3/2010. Per contra, on 8/3/2010, the serial number begins from 11596. This is presumed that thus it is presumed that the subsequent issue of Jamabandi was based on false and fabricated documents. But the various anomalies have also been detected in the same order.
Then,
Continuation.
Mhm.
Various anomalies have been detected in the same order. At para 8 of the petitioner himself has stated and admitted that had filed an application requesting the DC to forward his application to the government for legal regularization in his favor. However, the order dated 8/3/2010 is silent as to whether prior confirmation or approval has been made by the government. Moreover, I want to indicate that ownership of land only be decided in civil, civil court of country. So if petitioner has any grievances, he can approach the appropriate court. So what you understand is that the Indian order. It's not illegal, it is illegal, it was fast raising on the report of the legal. That's all. That's
This issue register is for reflecting which order?
the regularization order.
Regularization. Yes. Yes.
Yes. What should mechanically see, what should see that? What should also see that this is what they say, what they have did specifically is that it's an order pass on the section 145. What should I see that? It's specifically mentioned in data forms. That because of the statements, may just read the
Yes.
statement making back up to the petition.
Parafour of?
Definitely, that was just this. The statements making back up to the petition, definitely, Mr. Gasset, all of this, which should officer responding. Always clear the order was passed on the basis of position as and this is under section 145 with CRTC. Then not should again mechanical. Okay, what should mechanical back up 14? Just this 14. 14. 14. Page 6. With regards to the statements made in paragraph 16 of the legal petition, the government says the revenue or one second the land dispute under section 145 CRC and the 73 only in the aspect of position. Section 145 CRC is as follows. What should we can just keep this and kindly come to page 7 number. As issue relating to title right ownership are exclusively under the jurisdiction of the civil code. Keeping in mind of the provision of section 145 CRPC, the order in between the evidence, the revenue court has passed the interim order. Therefore, so one of what they are saying is this is an order specifically mentioning, repeatedly mentioning again and again, part of page 16 also. Paragraph 8, page 8, paragraph 16, then with regards to the statements in paragraph 18 of the petition, that the economic matter is under section 145. According to no other aspect can be limited. The person is striking, then he can approach any other form. So he has exercised his power under section 1. Revenue authority says I have no right to this. If we got knowledge, and this is a dispute about who is the owner of the land. But should man see section 145 was serious? What are the requirements? And has this requirement been made?
Yes.
Section 145 CRC. Procedure where dispute concerning land or water is likely to cause breach of peace. Wherever, whenever an executive magistrate, not revenue comes settlement officer, executive magistrate, section 20 of the CRPC says who can be how a executive magistrate is appointed. So here he was exercising as a revenue officer. Executive magistrate is satisfied from the report of the officer, police officer, or upon other information that a dispute likely to cause breach of peace exists concerning any land or water or the boundaries thereof. Within his local jurisdiction, he shall make an order in writing, state the grounds of his being so satisfied, requiring the parties concerned in such dispute to attend this court in person or by paper on a specific date and time, and to put in written statement of the respective claims as respect to the fact of actual possession for the subject of the dispute. Lordship, may I kindly pause here for a moment?
Hmm.
There has to be, he has to be certified. That there is a situation, my lord, there's a dispute which is likely to cause breach of this. And he must record this. He must record this. An order must be passed under subsection 1, that there's dispute and this dispute is likely to cause breach of this, and therefore I need to intervene. And therefore notice should be issued, my lord, and he will deal only with the possession, which is in possession. Because to restore possession and to so that the breach, this is not disturbed. Then lordship may kindly come to. For the purpose of this section, expression that lordship, we can split this is not illegal. We are dealing with land. 3 also, my lord, how the copy is to be served. That also not illegal. 4 is very important again, my lord. The magistrates and then shall not record refers to merit or claims, my lord. He cannot refer to the merit and claims of the parties. Of any of the parties to the right to possess the subject of dispute. Peruse the statement so put in, here the parties receive all such evidence as may be produced by them. Take such further evidence, if any, as it is necessary, and if possible, Mara, if only possible, decide whether any and which of the parties was at the time of the order made by at the plea of the order made by him under subsection 1 in possession of the subject of the dispute. So I should again make kindly possible. First of all, it says, Mara, he cannot deal with the merit of the claims and merit of the dispute of the parties. Secondly, Mara, only if he possibly will decide and what lordship, who was in possession at the time of on the date on which he was in an order under subsection 1. Now, Lord, is there an order under subsection 1? Or section 145 to follow? There has to be an order under section
So
1.
first tell me who is the officer here who's passed it? ADC.
No, my lord, revenue comes settlement officer. Usually he's in the rank of STO, my lord.
So is he an authority? Is he a magistrate under
No,
145?
they also make sure, my lord, because section 20 says who can be a
But he's a revenue officer. So what are his area? What orders can he pass with regard to revenue matters?
revenue matters, my lord, revenue matters, permanent revenues, first of all, permanent revenues, then also issues of
Which is the authority to deal with complaints under this application was filed under revenue regulation?
yes,
Assam
in
revenue.
Dimapur, that revenue regulation is followed, my lord.
Assam.
Assam, 1886, that is followed. That in the detail, my lord. But, Lordship, after that, if any order is passed by the revenue authority, then usually under that regulation, a tribunal is there, my lord. Revenue tribunal. In the state of Nagaland, we don't have that, so therefore we come under 26 to this honorable court.
There is no revenue board.
No revenue board. Yes. So therefore, this is the only remedy available, and this honorable court will be interfering in
No,
civil matters.
So tell us what orders can the revenue officer pass?
Lordship, revenue, Lordship, I'm also not an expert regarding such matters, how they deal with it. But
Do
obviously.
you have the Assam revenue, land revenue?
Settlement can be made also.
No other book.
Lordship can peruse this, I have a book, but may I just read what are the revenue?
Yes.
Settlement officer, their duties and roles have been given now. Lordship, may kindly see his officer. Yeah. Revenue officers. 203. Lordship, may kindly read section 126.1
Yes.
and regulation 126.1.
Yes.
The sub-division officer shall, in addition to any powers conferred by him or under this regulation, have the following powers of the deputy commissioner the power to dispose of certain gain by alluvium or by dereliction of river and lost by alluvium under section 34. Power to enter into a report on revenue free holding land and versus revenue on received land under service such. Powers conferred under section 50 in respect of registration. Power to attach some movable property belonging to before the under service. Subject to the confirmation of the Deputy Commissioner, power to receive application and produce all dates necessary for the effecting partition in the Union of State. State government may confer on any subdivision officer any of the powers of the Deputy Commissioner under the regulation. So, my lord, he is in the rank of Deputy SDO, and he has been conferred the power of revenue settlement officer by the government. Power taking. Power to find for omission to be notice of injury to boundary marks. Power conferred on the section 65 in the state of the opinion of the announced. Power conferred, so these are the powers. So, Lordship, now we have, Lordship, there are several cases from Assam where revenue authority had decided the title. Lordship.
Yes.
So therefore, my lord, this honorable court has clearly said that this is not the.
You come to rule 165. Rule 165.
This 165.
Regulation. Assam Land Revenue Regulation 165.
165. Engagement and regulation. In case of unsettled land, any person without any valid authority has encroached on or occupied it should be liable to agent for.
Number 2.
Number 2. In case of annually settled land, person other than the settlement holders, members of the family, as service in forming operation, shall be liable to agent for. The settlement with regard to settlement
Holder.
with regard to settlement holders shall understand earlier for infringement of the condition of release for any action contrary to the or inconsistent with the right of the client release, authority terminate and the period of the release. So therefore, first of all, person other than the settlement holder.
So therefore, revenue officer is has some powers to decide on who is the settlement holder.
Which is the settlement.
And if they find that there is any other person, there is a power in grain, issue orders for ejectment.
Now, what about my right as a settlement holder?
Your right will have to be decided by a civil court.
Yes, that's what I'm saying, and now I'm in possession.
No.
I'm in possession for such a long time, can it be ignored?
Revenue officer has to see what is available in the records.
Yes,
Now, you have placed a document which according to them is not available in the records. There is no record. They have gone to the extent of saying it is fabricated.
yes.
Right. So therefore, the revenue officer being confronted with these documents does not find your documents to be genuine. So therefore, it will pass an order in respect to a person whose documents are supported by the records, namely the private respondent. Now, if you challenge that order on the ground that they are not taking into account your title, or these records are not sent to you, or whatever it may be,
Can I go on my power of the land?
right, then you'll have to approach a civil court
Yes,
to that extent.
yes. This order, as Thomas is saying, he compelled me like this, because he has decided, he's given his observation. He's decided to marry Mama.
That you leave it to us.
You
But,
marry-
but if you want to, if you want your, see, the problem is coming from that side to this side, there's a problem. You see, the umbilical cord is always there. So I tend to say something more that is necessary. Don't take it otherwise. We are not competent to advise. Under the revenue, they will only see whether you have been given a proper revenue document in vis-a-vis the land, whether you have paid the fee, etc., all that. They have, in very clear terms, says there is no record.
Yes.
They have gone to the extent of saying it is fabricated. If that be so, prima facie,
Yes.
there are no documents in your favor. That makes you a person who does not have the settlement vis-a-vis that land. contrary to your claim.
Yes,
So therefore, if you now want a finding by any forum, it has to be the civil court.
all right. I was, so that this Russian wants me to do the civil court. Why?
Again,
No, no,
I
no,
don't
all
want
right.
you to go.
No, the remedy lies with the civil court to establish my title.
Maybe, yes.
That is,
No, this is,
understood.
this is. This is a, what, you see, your submission is that this order was passed under 145. Therefore, the parameters required under 145 is not there.
I'm not saying no, still is,
That's all right, but you are relying on that submission.
the state has said
Right.
so. I'm saying it's on a revenue side now.
So,
I said
so,
that.
so if it is, otherwise also it is a revenue side. Prima facie, I don't find whether this person is competent to pass an order under 145. Doesn't appear to be an executive magistrate. Maybe, we don't know, maybe he's given some additional charges. But he is definitely a revenue officer,
Yes,
no doubt on that.
yes.
Now, as a revenue officer, unless somebody questions his authority, ordinarily it is deemed that the whatever powers the DC has can also be distributed to other
Yes.
officers. So if the power is distributed, then there is a power under Rule 165, Regulation 165.
Russian, it's a settlement holder. So Russian is, it says settlement holder, a person who's not a settlement holder or whose settlement period has expired can be abused.
Right.
That's what it says. Now, whether he's a settlement holder or whether I'm a settlement holder, that has can be proved only through evidence. That is one, which I have to go to the civil, I have to prove it in the civil court. In fact,
No, unless you say that the finding of the revenue authorities that the records are not there
that's wrong. I'm
is,
saying
is,
it's-
is incorrect.
It's incorrect, Madam, that is my stand, it's incorrect, I have the papers, based on these papers, I've been there since 2008, Madam.
No, you
Without
need,
any interruption,
you will need something more
no,
than these papers.
Lordship, that what possession is ultimate. Because, Lordship, I kindly appreciate, I'm occupying a land, which is not my land. Which is not my land, I admit that the land belongs to her. I'm occupying them, she does nothing. It is open hostile occupation. I stayed there for more than 12 years, my lord. She makes a claim after 12 years,
So
her claim is barred.
who decides that?
The civil court will decide.
Correct.
Therefore, my lord, therefore,
The
that's what I'm saying,
civil court will have to decide that against the respondent in your favor.
yes, now, therefore I'm saying, since I am in occupation, if anybody wants to throw me out, that has the due process of law has to follow. That is due process of law means they cannot just evict me in this manner. They have to go to the civil court, establish their title,
That is-
because on
that
the
is-
basis of occupation, my lord.
That is one way. That is one way,
Yes.
but the regulations are also not denuded of powers for ejectment
Right.
as provided under these
Yeah.
regulations.
True. But my case is one of the occupation, my, forget about the, sorry, leaving aside the order. Settlement orders. Just on the basis of possession for a period of, long period of years since 2008, my lord. Let's count it from the date of the order passed.
No, but their
Or from 1990.
their plain and simple stand is that this file is
Is
not.
that enough? My case is that enough, my lord, in such a similar case. That's,
Then the question would be, what other materials are you placing to show that you have been in continued possession?
apart from that, my case is simple now. If you look at it, he has decided to title machine.
Is there any electricity connection?
No.
Is there any electricity connection?
Yes. Everything is there. Electricity connection. No, Lordship, my LEC, Lordship, has he not decided that? No.
Prima facie doesn't appear to be.
Has he not touched the merit of the case?
No,
Saying.
they are even under 145, they can decide on the prima facie title by looking into the
He
document.
can decide who was in possession.
That's right, that's right.
This time. That portion, that he has said this, he has not said since when I was there. He has not dealt with this.
They,
My claim that I've been there since so many years.
you see, you understand two things. If it is a case of the government
Yes.
that, yes, some documents were issued, but these are not authorized or not properly issued or not subsequently confirmed, then it is a question which prima facie says you are in possession. They have made a very categorical stand. The revenue file is not available. It is fabricated. So, which means that your presence in the land is not perhaps understood as possession, but it is more in the nature of a trespass.
Yes, Worship. That's what I'm saying. That's what I'm saying. When it comes to people, I'm a trespasser. I'm a trespasser. Everybody knows that I'm a trespasser. I'm in that land. But what to do, madam? The law of adverse possession is there. It says that stayed for a long year. All this right of the person, the true honor is relinquished, extinguished. So for so many years, my lord, he has done nothing. In 2022, they make a claim. So if he had any right whatsoever, assuming, my lord, that's extinguished.
So you approach the civil
Now,
court.
Lordship.
You
And
establish
this
your
order,
case.
this impugn order is there, my lord. Impugn order is there.
No.
I go to the civil court.
Impugned
This-
order, we'll observe that the findings of the impugned order will not be binding on.
And what
Civil court.
about my stay there, my lord, those families staying there? They have to be protected for some time, my lord, that till we approach the civil court.
That we can do.
Lordship, may I just inform some?
Judgments, yes, why not? So
Lordship, I
I have
understand.
not dictated the order.
I understood, my
I
lord.
have the bad habit of thinking aloud.
Yes. My lord,
So I think aloud.
It's better for us also, my lord,
But
so that I know the mind of the honorable. court.
so whatever has reflected on my mind, I have thought about it.
Lordship, that is better for me. I know the mind of the honorable court so that I can satisfy the body possible.
There's no disputes. There's no quarrel with the proposition that they cannot decide on the right title interest, the revenue. But for the purposes of revenue, exercising revenue powers, they can see what documents are available. Right?
Alright.
So they have taken a categorical stand, this file is not there.
Lordship, Lordship, again, this is one for.
But that,
One for, they have also come and said openly, the category again and then repeatedly said 145.
therefore,
Not a problem.
assuming it is not 145, you don't dispute that they are revenue officers.
No,
If
no,
they are
no,
revenue officers, then this,
The reason I came before this honorable court, I know that this was end there only. But this order will harm my case in the city.
we'll make an observation.
And also my family, those three family. Father, mother and daughter stay there, nowhere to discuss to move. Unless I get an order from the civil court.
But to give you an interim order till the disposal.
No, not the disposal, till I go, give me a certain time frame, my lord.
We'll give you that time.
My lord, give me certain time frame to oppose the civil court,
Yes.
then it's 2 months, my lord. Or
We'll-
2 or 3 months at the most, my lord, because civil cases preparation or civil cases takes time, till that, and also.
We'll do that. And we'll also observe that the findings of the revenue authority will not be binding on a
Yes,
property.
and then, my lord, till I get an injunction, till I file an
Then-
injunction, no, my lord, see, my lord, I oppose the civil court, no, till I oppose the civil court, give me
Yes.
3 months time.
Yes,
Till I oppose the civil court, my lord, protect me and my family staying there.
2 months should be good enough. 1 month
Fine.
is,
No,
1
2
month
months.
is more than good enough.
2 months, 1 month, too short. Because here, my lord, if they wants to come to me, they may go to somebody else for washing, you have to move around.
Yep.
In the surround, they may go to different
Why
posts.
are you apprehending that they will go to somebody else? Yes, these judgments are. First is issues involving right title, yes, no quarrel on that. Exactly. Does not confer any title. Dispute regarding matter of civil court. What is the judgment of 2015 that you have?
Actually, this was also similar case. My lord, here also I was sought to be evicted by the government. The petition was sought to be evicted by the government, my lord. And the government also had papa. These people also had papa. And government said, no, this land is not belongs to the government. The revenue officer, the DC, and sought to evict us. Now, lordship, the petitioner came saying that.
Yes,
So under 226, they came here, my lord. Because it's honorable court. And it's honorable process, eviction and cancellation of pata. Even the best pata was cancelled, my lord. That cannot be done by the revenue board. go to the civil court and the state government, that they're the respondent of the state government, madam. State government cannot unilaterally decide it in his favor, go to the civil court and the state was directed to go to the civil.
Okay. No, but here, where the stand is that they have not,
Yeah.
that the file is not there.
Lordship is saying, here lordship is already one aspect that is, my documents are not there. And therefore. that-
Prima facie something should have been there.
That is what is following the lordship, that is the one is different.
Again, without venturing to suggest anything,
Yes,
supposing you had applied from the RTI to call for the records of these files. And it comes in your favor that yes, there is a file containing, then this could have been dealt with in a different manner. So,
but we also looking that this will not end here, but this as long as this increase always, that's my.
So that
this
will
is
observe.
not them all.
that will ensure that it does not hamper the findings of the trial court.
Trial should not be affected by this.
No. Cannot be.
Temporary protection of.
No, it cannot be because they don't have jurisdiction to give you findings on the title, revenue officers. So whatever observations they have had will ultimately not affect the findings. We'll make it clear in the order. Yes, Mr. Jamir, is there anything more to be submitted?
Just want to make some clarification. Respondent number 4, I am preparing for respondent number 4. Respondent number 4 is the National Spiritual Assembly of Baha'is of India. It is a religious organization. Although I belong to the Christian, I have a lot of admiration for the principles of Baha'is, which they have adopted. And their basic principle, the core principle, is universality of religions and to maintain peace and to love peace. We are peace-loving association. So when it is a case of forceful occupation of my land, in spite of the fact that my learned friend has tried to reject a lot of facts, how they have acquired the Pata and all this, but fact remains that without any valid Pata, on the basis of an illegal Pata, he has encroached our land on 3rd of October 2022. Although he has taken law into his own hands, since we are at this lobbying organization, we did not want to confront in that manner. So as far as possible, we tried to resolve the matter. The land which is situated is a Sachet colony in Dimapur. Now it's in the heart of Dimapur.
Why don't you also practice what you want to preach?
That I will tell that Lord. Now,
You can include him,
now
allow them to stay in your
we
land.
have
Maintain
invited
everything.
the villagers, village council also look. So and so has encroached this land on this particular thing. Please say who has been occupying this area, land. All this.
Were
We
they
started
examined, were
with the
they,
village council.
were they examined before the revenue department?
They have been invited and then the session was taken, but ultimately we have approached the DC, the deputy commissioner, who is the competent authority, to evict the encroacher.
So why not file a suit for ejectment or eviction?
Now, we are claiming the title on the basis of a document, say Pada. To issue Pada. The revenue office, lordship is very aware. He will maintain a register of the allotment. Each and every allotment will be recorded in a register. It has to be in the Chitap. So the revenue officer will definitely examine if anybody claims the land. they will examine and verify from reports. And we will take a decision. In the present case, the petitioner has submitted a representation, complaint to the Jubilee Commissioner. We have also complained because he has encroached the fenced area by breaking the law. They have encroached and occupied. About 30 to 40 persons in numbers, they came with all the materials, broke open the gate, and then tried to occupy it. And then they are narrating their own story. That is one side of the story. We have our own story. Now, Lordship, in the course of the submission of my learned friend, Lordship has put a pointed query. That belongs to you or the respondent number 4 or government. Land is originally belonging to one Chikravili and Kami. The respondent number 4 has purchased it in 1997. According to all formalities were followed, and the government in favor of the respondent number 4. Since then, we have fenced the area of land also with brick walls. And from time to time, the organization used to organize functions by providing some game, playing games, children's, and then prayers, all this. We are not staying there permanently. Why? It is only a religious organization for a specific purpose. We have purchased the land and conducting different activities from time to time, periodically, not on the regular basis, because we are not there forever. Taking advantage of that situation, the petitioner has encroached on our land, and then suddenly they have constructed the tin house, and then tried to show that we are in occupation. It is a forceful occupation with an illegal manner. Very clear.
They should have gone for ejectment suit or eviction suit.
The issue of ejectment doesn't arise here. If a person encroach illegally, he should be evicted
By whom?
by the administration. Now, can they come? What is their complaint? Page 49. This is the complaint by the attorney holder about the present petitioner. I will just refer only to the relevant portion.
Page 49 of the red petition.
Page 49, sorry, page 49 of affidavit in opposition of respondent number 4.
Yes.
This is a complaint by the attorney holder, addressed to the commissioner, and the prayer which they have made.
Page
Page 49.
49.
Yes. Complaint against Sri Chakri Nayak, representative of National Spiritual Assembly of Kohima, India, for willful disturbance and illegal claim against my plot of land covered by Pata number so that number so is mentioned. Project can you come to page 52? What he has claimed. Page 52, second last paragraph. The same paragraph starts with therefore. National Secretary. Therefore, I beseech your esteemed authority to kindly depute necessary survey officials and verify the land in question, along with the parties concerned, ascertain the facts and tally the documents with the Chita report of both the parties. This is what he wanted. This is his application. He wants this. So, if any decision is arrived on the basis of this, and if it goes against him, whether I should go to the civil court or he should go to civil. If the order is passed in my favor against the order which has been passed in my favor, how I can go to a civil court? Now, with this complaint and our complaint is also there, So both the complaints were taken up. Our complaint is at page 46, which the Lord has already gone through. Now, to decide this, he has requested the authority to verify and depute the survey officials and verify the documents. Therefore, whether PATA is illegal or not is to be decided first.
There is no revenue board
No,
in
no revenue board.
Dimapur. No
Lordship
specific
is well
authority.
aware. District deputy commissioner is the district collector. In other states, it's like district collector. Revenue Councilman office is a branch in the DC's office, which is called as revenue branch, which is being looked after by Revenue Councilman office under DC, directly under the DC. So, if anything, complaint will be to the district collector. Now, under the nomenclature of deputy commissioner, this can come in. Otherwise, had it been in other case, when it is to do with the revenue matters, they are district collectors. But then, deputy commissioner in the state, and it is a part of the deputy commissioner office. It is a case of forceful occupation based on an illegal PATA, and the petitioner has approached the deputy commissioner to depute the survey officers and to verify the records of both the parties. Therefore, to decide this, who can decide? It is the revenue officer who can decide.
Yes.
So accordingly, the imperial order has been passed. My letter friend has just read out the imperial order, but I would like to refer to some portion which is relevant to decide this case. In the same affidavit, Lordship of
Now, the decision of the revenue authority is that there are no files or documents available in respect of the petitioner.
Yes.
The file is not available. And let us quickly have a look at the revenue impugned order. Where is that impugned order?
It's here in the same affidavit, Lordship.
Oh, okay.
Can you refer to my affidavit? Affidavit in opposition,
Right.
page 57.
57, yes,
I was going to refer to the relevant portion at page 58.
58,
Yes.
yes.
Second last paragraph, page 58, has not been correct.
Hmm.
Several issues were raised by both the parties. However, this court has dwelled into the issue pertaining to revenue matter only. This is very vital, Lordship. They are very clear. The state government is very clear that they are confining only to the revenue matters only. Nowhere in the petition, the petitioner has said that it is not a revenue matter. In spite of the fact that the district administration, the authority has said that we are confining only to the revenue matters. By approaching this court, the lead petitioner has not said in the petition that it is not a revenue matter. Only blaming the revenue officers by making a make-believe story. As I have already referred to the complaint, what you wanted. You want that records should be verified. So it was verified. Can you see the orders also? From page 59. Yeah, because this honorable court is to decide this order, whether it is valid or not, whether it is legal or not. So may I read from page 58, last paragraph. Written submissions, furnished documents, gist of arguments of revenue reports were duly produced. While producing relevant reports, revenue reports, it was observed that the disputed land was originally standing in the name of Shri Tikrumli Angami, who was regularized, allotted the land in the year 1990 measuring about so and so measurement is given, was accordingly issued to Sri Chakravarti Angami. In the year 1998, mediation case number so and so was registered in the Court of Additional Deputy Commissioner Dimapur Nagaland for an area of so and so particular circular at Sacho Colony Dimapur, standing in the name of Sri Chakravarti Angami, son of late K. Sacho. Under Law 50 to 51 of the Assam Land and Revenue Regulation Act 1886, the mandatory public notice was issued. A self-deed was executed and duly registered before the sub-registrar, bearing registration number so and so between Sri Chakravarti Angami and National Spiritual Assembly of Bahis of India. Accordingly, the land was mutated and separated from party number 442 in favor of National Spiritual Assembly of the Bahis of India by mutation number so and so dated 9/6/1988. The party number so and so measuring an area of so and so standing in the name of Sri Honitu Shohe, furnished by the respondent, that is the present petitioner, was recorded to be allotted by revenue number. so and so.
Mr. Jamil, just to interrupt you. So, you are not agreed by this order, obviously, because they have decided this matter. Now, there is some cloud as to whether this is an order passed under 145 or by the revenue officers. Now, let us say it is not passed under 145 and by a revenue officer. Then we have already expressed that if the records are not available, then we don't find any infirmity in the order. We can close this petition, permitting the petitioners to take recourse to proper action. And so far as the eviction part is concerned, we'll direct this part not to be applicable, not to be given effect to for 30 days, 45 days.
So, Chief, 50 days. Even allowing the petitioner.
See, essentially, we are dismissing your petition. Essentially, we are rejecting your petition, but we are closing it, giving you liberty to go.
In the observation that because this.
Of course, that will do you.
Yes. So many things are missing. Land was, yes, cases, the land was mutated, allotted to one T under in 1990. In 1997, that's one of the.
We are not going into the question of title.
That is so much. What I'm saying is, that is the case. There's a mutation case done, notice published. Where is it? How do I know? Because if the notice was published, I had a right to object. I did not know where which paper they had published. Mandatory notice, other section 51 and 52 of the Assam Land Revenue Regulation. Assam Land Revenue Regulation, no, 1997. Because I was in possession of the land. I was asking for regulation. Those bills were issued,
So these are the issues.
Yes,
you need to urge before the competent court.
Yes, the revenue
authorities.
was very biased,
Revenue authority, like I've said, they have made a categorical statement that the order, the file connected to the order is not available. So what are they supposed to do?
They have also not sought all those which is required to decide in his favor. What I'm saying now, my respectful submission. Therefore, let's go ahead and trash it down the civil court now. I have no problem. But like your worship says, can you give me some time, some protection till I go there?
On the strength of the order dated 23/8/2023, the petitioner is illegally occupying the plot.
Where is that?
He should not be allowed.
Where is that order of?
On the day of motion, this order was passed.
Which order?
The
Order
order has been stayed. Because he has been directed to vacate the premises and hand over the said land to the respondent number 4. That was the order of the revenue officer. But by approaching this court, by projecting his own set of the story, the interim order was obtained. So we filed an application for modification and vacating the interim stay. But then parties have agreed that instead of considering this, let us dispose of the entire matter, so we waited. And in fact, that has benefited the petitioner also by delaying the
Now,
matter.
how is this order to be implemented? Order
As in terms of this order,
will implement it, execute this order, how?
I doubt it.
Yes,
He is an illegal occupation.
that's right, but what is the process for removal? It has to be by due process of law. Even under revenue,
Eviction order has already been issued earlier.
Hmm.
Notice was given.
so therefore, we will direct both parties to maintain status quo. For,
No, status quo is, he has forcefully entered the premises and he is occupying there. And that was ordered to be vacated
no, that's all
by the
right.
order, by the eviction order.
Status quo in respect of the extent,
Status of the land,
no,
but not the occupation.
the extent of eviction of the petitioner from this land. And also no further constructions without,
Okay.
no change on the land.
This one. Now very on outcome.
Yes, Mr. Jamir,
Lordship?
should we dispose it off
Yes, Lordship.
in that terms?
But so far as occupation is concerned, if he is allowed to occupy, then it will encourage an illegal encroachment to occupy.
We are not allowing him. We are only saying that this penultimate portion of the order seeking eviction will not be implemented for another 30 days
Lordship.
or 40 days or whatever it is. And the findings of this order, the finding of the revenue authority whatever finding they may have given in respect of the title will be subject to such orders as may pass by the civil courts. Will not affect the findings of the civil court.
Yes.
Yes, government.
And paragraph 17 of the government affidavit will be relevant with regard to the section 145. Because they have referred to paragraph 14 and 19 only. But paragraph 17 of the government affidavit is also one of the basis besides section 145 of CRPC law.
That is his case. The revenue court cannot look into it.
Should go about solution.
What I heard. Learned counsels for the parties. This writ petition is directed against the order. Dated. Is it 11th?
Yes.
11 August 2023. You write order number so and so. Number is at page 23. Number so and so dated 11 August 2023. Passed by the Revenue Cum Resettlement Officer, Dimapur, Nagaland. Whereby the petitioner was directed to dismantle the Kacha house constructed by his attorney holder, Sri Akhalu Achumi, vacate the premises and hand over the said land to the National Spiritual Assembly of the Baha'is of India. Stop. The petitioner was directed to hand over the land free from all encumbrances within 14 days from the date of receipt of the order. Stop. This court by order dated 22/08/2023 directed parties, while issuing notice, directed parties to maintain status quo. on the land, on the concerned land, and further directed the respondents 2 and 3 not to take recourse to any action for cancellation of patta number 1683, DAG number 19/1845 in block number 9, Mauza number 2, measuring an area of 1 biga 3 quarters 2 laches. Stop. Well, learned counsel for the petitioner submits that this that the land had been in possession of the petitioner since 1989, and it was regularized in the year 2010 by the Deputy Commissioner Dimapur by issuance of Jamabandi/Patta in favor of the petitioner. Stop. The land in question is covered by Patta number 1683, DAG number 19/1845 under block number 9, Mauza number 2, Dimapur, measuring 1 biga 3 quarters, which the petitioner claims had been under his possession since 1989, and which came to be regularized by the Deputy Commissioner Dimapur by issuing Jamabandi Patta. Stop. It is submitted that while the petitioner was in peaceful possession of the said land, he appointed one Akalu Achumi as his attorney. As the petitioner originally belongs to Luthsumi village in the district of Junheboto in the state of Nagaland. Stop. It is the case of the petitioner that in the year 1989, the petitioner had cleared the jungle from the land in question, and the said land was unoccupied nor was registered in the name of any person. Stop. At the relevant point in time, an area near the concerned land in question was occupied by the GREF. Stop. The petitioner used to supply wood from the clearing of the jungle to the Assam Rifles camp at 3rd Mile Dimapur. Stop. As such, since 1989, the concerned land has been under the possession of the petitioner. Stop. The petitioner filed necessary applications for regularization and settlement before the additional Deputy Commissioner Dimapur by application dated 20/11/1992. Stop. Earlier, Dimapur was a subdivision and it came to be established as a district headquarters only in 1997. In pursuance to the applications furnished, filed by the petitioner before additional Deputy Commissioner for allotment of the land in question, the petitioner was informed by the Office of the Deputy Commissioner that there is a ban for allotment of land by the government, and the land therefore could not be settled or regularized in his name till the ban is in force. Stop. Better. Subsequently, the petitioner renewed his prayer by filing separate applications. Stop. During the pendency of this application, petitioner left Dimapur to return to his original village and put the land in the care of one person, namely Sri Pandey, who the petitioner appointed as a caretaker in respect of the said land. Stop. Subsequently, the petitioner was informed sometime in the year 2008 that the caretaker was chased away from the land by some unknown persons. Stop. Returning back to the said land, he found that the land was surrounded by a boundary wall with a gate. Stop. Immediately thereafter, the petitioner pursued his claim for regularization of the land in his name. The office of the DC by order number REV hyphen 17/90 hyphen capital D for Delhi slash 11212 hyphen 15 dated 8/3/2010. The land was regularized in the name of the petitioner by the order passed by the Deputy Commissioner Dimapur. Stop. Thereafter, the Jamabandi was also issued in the name of the petitioner for the land measuring 1 bigha 3 kotas and the patta number 1683, tag number 19/1845, block number 9 and Mosa number 2. Stop. The petitioner also paid the necessary land revenue and a certificate to that effect was issued by the competent authorities in favor of the petitioner. Stop. A non-encumbrance certificate dated 25/8/2022 was also issued by the Deputy Commissioner Dimapur in favor of the petitioner. Stop. Pursuant to the plot of land being regularized in the name of the petitioner, he permitted his attorney holder, Sri Akalu Achumi, to construct a bamboo thatched house with a tin roof on the land. Stop. The said attorney holder, Sri Achumi, and his family are residing on the said land in the said thatched house. Stop. Thereafter, sometime in the later part of the year 2022, some persons claiming to be representatives of the respondent number 4 came to the said land and accosted the attorney holder of the petitioner, claiming that the land belongs to the respondent number 4 organization. So they claimed that the land was purchased from one Tekru Vili Angami in the year 1997. initially, the complaint was lodged by the uh, representatives of respondent number 4 before the Sachu Colony Council. Stop. Subsequently, the attorney holder of the petitioner was served with the order number REV hyphen 02/2018 hyphen capital D slash 9836 hyphen 38 dated 28/11/2022 issued by the respondent number 3. The said order was passed by the who passed that order? By the Revenue Cum Settlement Officer, Office of the Deputy Commissioner, Dimapur, referring to a complaint filed by the respondent number 4. Stop. The said order restrained the attorney holder of the petitioner from carrying out any further construction or developmental activities till the settlement, till the matter is settled by the office. Stop. Summons were thereafter issued to the attorney holder of the petitioner, and he appeared before the competent authority. Stop. In spite of it is submitted by the counsel for the petitioner that in spite of the requests made before the office of the Revenue and Settlement Officer, a copy of the complaint was not served on the petitioner. Stop. However, the gist of the argument filed by the respondents, representatives of respondent 4 was served on the petitioner. Stop. During the pendency of the said complaint filed by the respondent number 4, the petitioner also filed his complaint before the Revenue and Settlement Officer, Office of the DC, ID complaint dated 10/4/2023. The complaint was lodged against the respondent number 4 of illegally occupying his land, which was allotted pursuant to orders issued by the competent revenue authorities. Stop. The matter was heard, in the presence of both parties, and a detailed order was issued by the Office of the Settlement Officer. Revenue, what is that? Revenue Cum Settlement Officer. Dimapur. Nagaland. Stop. The by the said order, the petitioner was directed to dismantle the Kacha house constructed by his attorney holder and vacate the premises and hand over the said premises free from all encumbrances to the respondent number 4. Stop. Para. Before this court, learned counsel for the petitioner submits that this order was issued by the Revenue Comes Resettlement Officer And a perusal of the order appears, the perusal of the order along with the complaints filed reveals that this order was issued by, under the provisions of section 145.
That's what the state said, I'm saying it's
Okay. All right, you strike out that part. Counsel for the petitioner submits that a perusal of this order reveals that the officer, the authority who has issued the impugned order, namely the revenue cum resettlement officer, has exceeded his jurisdiction and decided upon the title of the petitioner vis-a-vis the claims made by the respondent number 4. So is submitted that the revenue officers have no power entrusted under the relevant statutes governing revenue regulation and settlement to decide on any aspect of the right, title, and interest over any land. So he submits that the tenor of this order is, from the tenor of this order, it is very clear that they rejected the claim of the petitioner, holding that he has no title and right to possess the premises, and decided the matter in favor of the respondent number 4. Stop. He therefore submits that the revenue authority is not being competent to decide on the right, title, and interest of any person. This order is bad in law, and the same should therefore be set aside and quashed. Stop. He submits that since the revenue authorities have no power, are not vested by law to decide on the right, title, and interest of any person, they cannot consequently, they cannot issue any orders directing the petitioner to be evicted from the said land without first a proper decision on the right, title, and interest in respect of the petitioner vis-a-vis the respondent number 4. Stop. Learned counsel appearing for the petitioner, referring to the authorities placed before the court, submits that the consistent view of this court as well as the apex court is that it is the civil court which is the proper forum for a decision on the right, title, and interest in respect of any claims over properties. Stop. He submits that the Assam Land Revenue Regulation 1886 is being followed by the government of Nagaland and is applicable in the district of Dimapur and the land under the same district. Stop.
district,
Dimapur town is applicable in Dimapur town, not in the district.
Mosa, Mosa is used in the law.
Huh?
Mosa, that's the word used in the law, a lot of things.
Dimapur Moza is a part of the Dimapur district.
Yes.
So the entire land in Dimapur is not
No, just the Dimapur town area.
town area.
It's Dimapur Mausa and the present land falls under that.
Okay, it's applicable under Dimapur Moza in the district of Dimapur. And the land in dispute, land in question falls within that Moza. Stop. Learned counsel for the petitioner therefore submits that since the order passed by the concerned revenue authorities is beyond the powers conferred under the revenue regulation, Assam Land Revenue Regulation 1886. And the authorities have proceeded to decide on the right, title and interest, which they are incompetent to do so. Comma, the impugned order be interfered with, set aside, and the petitioner be permitted to continue his possession, peaceful possession on the said land without any interference by respondent 4 or any other authorities. Learned counsel in support of his submissions as referred to the following judgments. Yes, copy it from there. Para. The respondents are led by the government advocate, appearing on behalf of respondents 1, 2, 3, and have contested this case by filing their counter affidavit. The respondents submit that, referring to the affidavit in opposition, the respondents submit that on the basis of the complaints filed by the petitioner as well as by the respondent number 4, the authorities proceeded to hear both parties and examine the relevant records and have thereafter passed the order which is impugned in the writ petition. Stop. The learned government advocate submits that there is a categorical finding in the impugned, in the order which is impugned, that the order which the petitioner claims was issued regularizing the land in question cannot be traced in the revenue records available in the concerned office. In fact, the concerned file is not available. The concerned file cannot be traced in the revenue branch. Further, the issue number of the allotment order number REV-17/90-D for Delhi /11212-15 dated 8/08/03/2010 also cannot be found in the issue register maintained for all letters/orders stated to be issued by the office. Stop. The report given by the, what is DLRSO? District
Survey officer.
Land Record, Land Revenue and Settlement Officer. What is DLRSO? DLRSO.
Question is land records.
Land Record. Okay, District Land Record and Survey Officer, Dimapur. In his verification report for patta number 818, dag number 928, block number 9, Mosa number 2, standing in the name of the respondent number 4, stated in his report that the ground position, this will be in italics, ground position found tallied with the revenue record Stop. This plot of land is outside ROW, what's closed. The said report, however, a said report further states that the patta number 1683 in respect of the writ petitioner is not found in the resettlement chitta record. Stop. Learned government advocate submits that it is under these circumstances that the order dated 11th August 2023 was passed, and the petitioner was asked to dismantle the Kacha house. And the petitioner, not having been found in lawful possession, was asked to dismantle the Kacha house constructed by his attorney holder and vacate the premises and hand over the said premises free from all encumbrances to the respondent number 4. Stop. The learned government advocate further submits that this order was passed under the provisions of section 145 of the CRPC, as both parties had filed a complaint and it was necessary to pass this order to maintain law and order, to maintain peace and tranquility. Stop. Better. Mr. C.T. Jamil, Learned Senior Counsel, assisted by Mr. Ayin Chen. The counsel representing respondent number 4 also strongly disputes the submissions of the learned counsel to the petitioner. He submits that the respondent number 4 has also filed an affidavit contesting the claims made by the petitioner. It is submitted that the land has been lawfully settled in the name of the respondent number 4. And the petitioners and the respondent number 4 took steps to barricade the said property by constructing a boundary wall with a gate. So, however, the respondent number 4, being a spiritual organization, does not conduct its activities on a day-to-day basis on the said plot of land. As and when required, members of the respondent number 4 gather together and conduct the proceedings as required in pursuit of their spiritual, in furtherance of their spiritual pursuit on the said plot of land. So, taking advantage of this situation, the petitioner usurped on the land and illegally constructed the thatched house, trying to project that he's been in possession.
Tin house. Initially, you were claimed that he had constructed a thatched house. When he encroached, you have constructed a temporary tin.
A tin house, as opposed to the claims made by the petitioner of construction of a thatched house, and thereby they were trying to project that the land in question was under their possession since long. So, Learned Senior Counsel has also submitted that there is no dispute that the land is surrounded by a boundary wall with a gate, and which the petitioner does not claim that he has constructed the same. Stop. He therefore submits that since the petitioner and his power of attorney holder did not hand over the land in the portion of the land in question. Is it the entire land or part of the land?
Entire.
Oh, entire land.
Yes, and we are paying revenue till 2023, like revenue.
Did not hand over the peaceful possession, free from all encumbrances. They filed a complaint before the DC Dimapur to take necessary steps in removing the illegal encroacher, namely the writ petition. So, Learned Senior Council also submits that the respondent number 4 has been regularly paying land revenue and has paid land revenue till 2023. So, under such circumstances, the upon notice being duly served on the petitioner and his representatives, the matter was heard in the presence of all the affected parties. The relevant records were duly examined by the revenue officer, and thereafter, the order dated 11th August was issued directing the petitioner to vacate the premise, dismantle the house, and hand over the peaceful possession of the land free from all encumbrances. So, it is submitted that there is no infirmity in the order, as there is a categorical finding in the order itself that the documents pertaining to the settlement orders stated to be in favor of the petitioner, relied upon by the petitioner before the revenue and settlement officer, are not traceable, are not accepted by the revenue officer in view of the concerned file, which in which the said orders were stated to have been issued, could not be traced in the revenue office. So, Learned Senior Counsel refers to the averments made in the affidavit filed by the state government, that as well as to the order impugned, that the revenue authorities have held that this order placed by the petitioner in support of his settlement appears to be forged, and it appears to be forged. Stop. The Senior Counsel therefore submits that there is no merit in the writ petition, the same should be dismissed, and the impugned order should be allowed to stand. Are you relying on any authorities? You're relying on some authorities, judgments? Okay. There's one more submission you write before that last line. Learned Senior Counsel vehemently argues that if the petitioner is confident of his title over the said land, the same should be, he should approach a proper civil court to ventilate his grievance. Stop. Until such steps are taken by the petitioner, there is no infirmity in the impugned order, in the order dated so and so impugned the present writ petition issued by the revenue authorities. Anyway, therefore, there is no infirmity, petition should be dismissed. Para. Learned counsels for the parties have been heard. pursuant to the order dated so and so, whereby a status quo order was granted, the respondent number 4 filed an IA, being IA number 116 of 2023, seeking vacation, alteration and modification of the order dated so and so passed by this court while issuing notice. Stop. In terms of the orders passed by the court, this vacating petition was to be taken up together with the present application. When the matter is required to be heard. Stop. Accordingly, no separate orders are being passed in the IE number so and so, so and so. So. There. A careful perusal of the order dated so and so issued by the revenue officers, revenue and settlement officer, Demapu, as well as the individual complaints filed by the petitioner as well as by respondent number 4, reveals that the complaints are not with regard to a decision on the right, title and interest, respective right, title and interest of petitioner or respondent number 4. So the complaint filed by the petitioner before the DC was to depute necessary survey officials, verify the land in question along with the parties concerned, ascertain the DUGs, tally the documents with the SITA report of both parties. Stop. Whereas the petition complaint filed by the respondent sorry, the first is by the respondent number 4. First complaint is by the respondent number 4.
It's 10/10/2022.
10/10/2022. And whereas the complaint filed by the petitioner sorry, sir. 49 is by the complaints. Complainant is by the petitioner.
Petitioner.
Okay. You write, the first one is by the petitioner, whereby the request was for so and so, survey of land and verification. And where is your complaint?
My complaint is at page 46.
46.
It is 10/10/2022.
Where is the complaint filed by the respondent number 4, dated 10/10/2022? Requested the authority to look into the matter as genuine and requested the authority to stop the encroachment by the petitioner and evict the illegal occupation by the petitioner in the said land by verification and demarcation. Stop. Was there any verification undertaken? Physical verification by the officers?
There is, some, it's a bunch of has gone. I'm not aware. I've never really seen officers.
Dealings for deputed lordship in the Indian order it is mentioned.
Who is DB?
Togashis,
Okay.
they are the representative of the deputy commissioner.
pursuant to,
Lordship, in, if Lordship is holding my affidavit of respondent number 4, page 57.
yes,
Second paragraph.
verification,
Verification of the site was conducted by the head David Timako.
all right. On the basis of the site verification conducted by officials deputed by the office of the Deputy Commissioner Dimapur, Nagaland, and upon examination of the relevant revenue records, and also upon hearing the parties to the dispute, the Revenue cum Settlement Officer, Dimapur, Nagaland, by the order dated 11/8/2023, allowed the complaint made by the respondent number 4 and directed the petitioner to vacate the premises and hand over peaceful possession free from all encumbrances to the respondent number 4. So the relevant directions, the directions contained in the order. The findings and conclusions of the officer and the directions are extracted below. Take up writ petition. Page number 25, after considering the above facts, till the end. A careful perusal of the order reflects that there is a finding by the revenue authorities that the allotment order in favor of the petitioner cannot be traced to the concerned revenue record, as the same is not available in the office store. The authorities further categorically held that even the issue register does not contain any particular regarding the date and the issue number of the mutation order. What is that mutation order? Mutation order stated to have been issued in favor of the petitioner. Stop. Insofar as the stand of the respondent government department is concerned, that this order was passed under section 145, the CRPC. A careful perusal of the section reflects that the orders under 145 CRPC are required to be passed by executive magistrate concerning any dispute over land or water when it is likely to cause a breach of peace. The respondents have not placed any material to show that the revenue cum settlement officer is also vested with the powers of an executive magistrate competent to pass orders under 145. So The specific power empowered under section 145 CRPC is to provide for maintenance of peace and to ensure that there is no breach of peace in respect of any dispute concerning land or water. So, whether the penultimate directions in the order dated 11/8 passed by the Revenue and Settlement Officer requiring the petitioner to remove, dismantle his tin house and hand over physical peaceful possession free from all encumbrances would have been issued by an executive magistrate under section 145 is an issue which need not detain the court at this stage. The reason is that even assuming that the Revenue and Settlement Officer or even assuming that the Revenue and Settlement Officer was not a competent executive magistrate pass orders under section 145 in the absence of any such orders being issued in favor of the Revenue and Settlement Officer, Dimapur, by competent authority, the fact remains that there is no dispute that the Assam Land Revenue Regulation 1886 is applicable to the Dimapur Moza and the Dimapur town within the district of Dimapur. Stop. Regulation 165 provides for ejectment and eviction of unsettled of a person who without valid authority had encroached upon or occupied the same. Stop. The revenue authorities are empowered to declare that persons other than settlement holders and the members of the family and hired servants are alone entitled to remain in lands which are duly settled. Stop. Any unsettled person found in such settlements are liable to be ejected forthwith. Stop. In view of such clear provision under the Assam Land Revenue Regulation 1886, there is no dispute that the Revenue and Resettlement Officer is a revenue officer under the Deputy Commissioner Dimapur and is empowered, unless shown otherwise, to pass orders under section regulation 165. Stop. Error. There is no contention on the part of the petitioner to submit that the Revenue and Resettlement Officer is not a revenue officer empowered under Assam Land Revenue Regulation 1886. Stop. Referring to the judgments, under such circumstances, it has to be held that Revenue and Resettlement Officer is a revenue officer under the office of the Deputy Commissioner, Dimapur, and is otherwise competent to pass any orders as found necessary under the provisions of Revenue, Assam Land Revenue Regulation 1886. So, better. Under such circumstances, prima facie, this court does not find any irregularity in the order dated 11/8/2024, passed by the authorities. Stop. Sorry, 8/11/2023. It cannot be said. That's what I said. Oh, 11/8/23. It has to be held that the authority who passed the order in view is competent under the Assam Land Revenue Regulation to pass the orders and the directions contained therein. Stop. However, what concerns the court is that in notwithstanding the finding that the revenue records from which revenue records connected to the settlement order stated to have been issued to the petitioner was not traced, or that the issue register did not contain the order dated so and so issued by the deputy commissioner, deed and deputy commissioner, no steps are seen to be taken by the revenue authorities to conduct a proper inquiry to find out and retrieve the revenue file stated, which is stated to not have been available or traced in the revenue department. Stop. Under such circumstances, the question whether the settlement order is indeed a forged order is to be decided, and from the order dated so and so passed by the revenue and settlement officer, it cannot be said that there is a clear finding based on evidence that the order dated, settlement order dated so and so is a forged order. Stop. Under such circumstances, the question on the title, right title and interest of both the parties can only be decided by a competent civil court, by a civil court of competent jurisdiction. So the judgments pressed into service by the petitioner are on this aspect, and on which principle there is no quarrel. So
The entries in respect of the petitioner is not, the file is not available, it's not the case, but the register which is being maintained for issue of Pata and Jita reports, it's not there under. So
That's right.
Some file is missing on that side.
we would not like to put it in the order, but the fact remains that there is no inquiry by the DC office.
That regard,
There has to be. You can't say the file is not available.
it's not available on the reports. That's what it is
So,
mentioned.
but that doesn't settle the matter. They must find out what happened to the file.
When by that, it may presume that there is one file which is not available. It is not that,
Right.
but the records which is maintained for entering the Pata or Chita record, it's not there. This entry is not there.
Right.
That is
So,
what it.
so there has to be a finding that it is forged. Now you can't return a finding merely because it is not there on the issue register. That has not been done. So we are not going into this aspect now. Under such circumstances, it is, this court is of the view that this order impugned in the present writ petition does not call for any interference at this stage. However, taking note of the findings made by the revenue authorities in the order impugned dated so and so, that the record has not been traced, the connected revenue record is not traced in the office, or that the issue register does not contain any entry regarding the issuance of the settlement order, and further, no inquiry or attempt has been made or has been shown to have been made by the department in this regard, the question of whether the documents of the writ petitioner are found to be forged is left to be answered by a competent civil court. Stop. The question of right, title, and interest of the writ petitioner, either by way of the documents issued by the Revenue Department or by way of adverse possession, are required to be decided by a civil court of competent jurisdiction, which the petitioner may approach if so advised. Stop. However, having said that, we dispose of the writ petition without interfering with the order dated so and so. And taking note of the submissions made by the counsel for the petitioner, that the petitioner, if so advised, may approach the competent civil court for one. We direct both parties maintain the status quo as directed by this court by its earlier order dated 22/08/2023. More particularly, in respect of the penultimate directions contained in the order dated 11/8/2023, namely, in respect of dismantling of the Kacha house and handing over vacant possession of the land to the respondent number 4 for a period of 30 days. In a period of, let us be little more liberal, 45 days. 45 days from the date, from today, not from the date of receipt, from today. From today, and stop. If the petitioner approaches the civil court, and if the civil court considers it appropriate on due consideration of all materials that may be placed, will not write so much.
Yes.
This order, the interim order will continue till 45 days from today. Stop. It is open to the competent civil court as and when the petitioner approaches to pass any adequate interim orders if the court considers it appropriate. And Hmm.
You know, they should not be used to.
The findings, if any, with regard to the right title and interest of the petitioner arrived at by the Revenue and Resettlement Officer, passed in the order impugned in the writ petition dated 11/8/2023, will not influence the civil court of competent jurisdiction to decide the matter independently in accordance with law. Writ petition disposed of in terms of the above, and no order is to post. In the IA, you write in view of the order passed, IA stands dismissed.
Chair order pass on 22nd
22nd/8.
merge with the federal.
No, we said it will continue till 45 days. That's all. Sorry for holding you for lunch.
Also, we call the assistant.
बोला घरी जे टिफिन खायचं बघ. आणि तुला किती तुझ्या
Yes. Okay.
Not for ignoring this. Who is not mentioned, but not everything. If this can have on Monday, please.
31, 32.
Yes.
Item 31, 32. As requested by the learned counsel for the petitioner. Matters be listed on Monday would be 18th. For admission. For admission. Admission, there's no admission hearing column, it's for admission.
The practice we have here is this is. Mentioned in the meeting hearing and then fixed so that matter can.
All right, it is,
Already, can you pass in the orders?
an attempt will be made to dispose of the matter. Attempt may be made to dispose of the matter on the next date. Huh?
For admission, item number 8 to 10.
Apologies for everyone.
Oh.
Before proceeding today's case, I may be allowed to mention the earlier item number 1 and 2 as I the button to sit for interview
No, what order was passed?
1 and 2.
You had withdrawn the IA.
Yes, for the main petition interim.
We don't know, you should have mentioned, you have mentioned it now after 3-4 hours. You file an application if not there. When are the matters fixed?
We have.
We'll check up, you remind me, we'll check up if there is any interim order, will be continued. Yes. Yes, now. 7, 8, 8, 9, 10.
Item number 8 to 10.
Yes. Yes, please.
Yeah, this is Roshi. I'm Roshi, I'm appearing on behalf of Council for the Petitioners. Your Lordship, due to unavoidable circumstances, the Council for the Petitioner recommended. So I pray the reader be listed on next Tuesday.
Prayer is made on behalf of the council to the petitioner that he is unavailable in court today. Stop it is prayed that the matter be listed on Tuesday,
Next Tuesday.
19th.
Yes, Your Lordship.
The matter be listed on 19th, list accordingly on 19th for admission. Yes. Learned counsel so and so appears for the respondents.
Item number 14 and 15.
What about 11? 11 is mentioned. Okay.
Your Honor, if I may.
Yes.
Your Honor, in the last hearing, Your Honor requested that for today's hearing, I appraise the court as far as the health issues that I'm having. I have done the medical checkup, and the doctor has stated that I have bilateral ear infection, which is causing the symptoms that I've been having. And end of the week, I will have a follow-up checkup as far as the perforated eardrum is concerned.
Fast forward. Just a minute, we'll check on the last one.
Yes, Your Honor.
The other gentleman is also appearing in this matter. Are you appearing in this matter? The gentleman we see on the screen, are you appearing in this matter?
Lord, yes, my lord.
In this matter?
Yeah, I am representing R1 hospital.
Okay. You're appearing as a counsel?
Yes. Counsel for R1.
Where is the, where have you filed the application against counsel? What is the number?
65,
Is
Your
it the
Honor.
IA?
Yes, Lordship.
Yes.
I 65 of 2024. And I 58 of 2024.
No, IA 65, who has filed it?
Petitioners, Lordships.
Uh, Petitioner in person, Mrs. Nunes,
Yes, Your Honor.
you have filed this IA for certain directions
Yes, Your
against the
Honor.
council,
Yes,
against the advocate.
yes, Your Honor.
You have already approached the licensing authority, which is the Bar Council.
Yes, I approached them on the say-so of the court.
Right, so the matter is being, proceeded, matter is being pursued before the Bar Council.
Yes, Your Honor.
Now,
But,
what further orders do you want from the court?
Your Honor, as the forgery and the tampering of court records was done upon the High Court under Section 340 of the Code of Civil Procedure, the court has jurisdiction to take action against such criminal action. So our request to the petitioner is that the court looks into it.
What are the, how have you pleaded the acts of forgery and tampering of court records?
Your Honor, if you look at the IAs and all of the IAs, every signature is completely different from one another. But it's not one person that signed. It's very clear to see. Anyone can see that those signatures are not signed by the same person. And those IAs, in IA
Which IA are you referring?
15, 16, 17, no, sorry, not 17. Your Honor, actually, the court has requested for me to appraise the court as far as my health condition, and that if I need, that I could get a further adjournment. So I would like to pray today for a 3-week adjournment to have enough time to recuperate from my illness.
There is some
and
disturbance
also,
in the line. Some disturbance in the line. We can hear you clearly. Yes, can you repeat?
yes, am I audible now?
You are audible, but there is a break in your voice.
Okay.
Can you repeat again?
Yes, Your Honor. The court, last week, the court has required me to appraise the court as far as what my sickness is. And I have that. If the court would like, I can show it to the court.
Yes, that's okay.
Yes. So
know why
I would like to get a 3-week adjournment to have enough time to recuperate, as I'm not currently in the position to go ahead with the hearing.
No, that's quite all right. But you have preferred an application before the Bar Council against the lawyer, isn't it?
Yes.
Now, in view of the pendency of the matter, the Bar Council will not be able to proceed in the matter in your complaint.
Why not?
That's
Those
the
are two
law.
separate.
You have filed before this court asking for orders.
Yes.
And you have also approached the Bar Council.
The Bar Council I've approached as far as the Bar Council jurisdiction is concerned. As far as the
right, but
they cannot pass orders as far as the tampering of the court records. That's not in their jurisdiction. That's the court's
that's a matter of
jurisdiction.
evidence. You have to show us from the evidence.
Yes.
How do you show us from the, how do you show us?
Yes, Your Honor.
What are the materials you have placed?
Your Honor, if I may, I would like to request for an adjournment. I am not in the current state to be able to argue the case today.
We inquired on the last occasion whether you'd like to have a counsel, you declined.
Yes, Your Honor.
We are renewing our query. If you want, we can request the District Legal Services Authority or the High Court authority to provide an adequate, appropriate counsel for you.
Your Honor, I would like to decline. I just need extra time, Your Honor. Your Honor, all the opposite parties have requested multiple times the court for adjournments, for extra time, for fixed date, unfixed date, and petitioners have never once objected to it. They've also called me and WhatsApped me requesting me for adjournments. And I've always obliged because, of course, they're human. Sometimes they might be sick. Sometimes they might have multiple engagements at the same time. So I've never, objected to it. But the one time that I need an adjournment, a legitimate need for my ill health, why it cannot be, the same consideration returned back to the petitioner?
You
I don't
can. We
understand.
are considering your prayer. We considered you last time. We are only asking you what are the materials on which you have filed these IA praying for orders. That's all.
Okay, Your Honor.
You are appearing through VC. I'm
Yes, Your
sure
Honor.
you decline the query of the court or request of the court to be engaged by a lawyer. So you are well versed with the pleadings.
Yes, Your Honor.
So just point it up to us. What are the grounds on which you want? That's all we are asking for.
Okay, Your Honor. So under section 340 of the Code of Civil Procedure, the High Court, any court where fraud on the court is committed, they have the jurisdictional right to investigate the preliminary hearing, which has, and the Honorable Justice Kaketo Sama has agreed to implead the advocate in the matter. So the petitioner's request is that the court looks into the matter, because the forgery of the signatures and the tampering of court records has impeded justice
What are
to
the
be served.
instances of tampering? That's what we're asking you. White
The
basis
Vakalatnama,
on
which
you are
was in the
making
court's
allegation of
possession,
tampering.
yes, the Vakalat was in the court's possession, was tampered with. It was white out, names were white out. A signature of a different advocate has been added to the Vakalatnama. Your Honor, the advocate has confirmed that her signature was also forged, and she is willing to put on affidavit in the court of such,
You bring that
that
you
her
bring that
signature was
affidavit
forged.
first. You have to bring that
But
affidavit first.
she's willing to put on affidavit that yes, her signature was also forged.
Her willingness is not enough. You have to bring it on record. You're making a
Then
serious
I
allegation
request,
against
yes,
a counsel.
not lightly, Your Honor. I have not done it lightly.
Counsel who has harmed her, beyond my means, Lordship.
No, that's okay.
In fact, I was harassed a lot, Lordship. Why provoke another counter litigation? It's what? Because it's not going to help your case in any way, Lordship.
It's for them to decide. Yes, what Wakalat number are you referring to?
The Vakalatnama signed between the petitioner and
Where is the order impleading the petition, the counsel? Where is the order?
the
In
order
which
was
date and in
filed.
which application?
I'm sorry, Your Honor. I wasn't well prepared for today. The order was, I think it was a 141. No, sorry. That was for my improvement. Your Honor, I really request for an adjournment. I am not in the position. I am quite unwell today. My thoughts are quite scattered.
You were unwell, therefore we wanted a lawyer to be represent you on your behalf. You are not willing to accept that request. You don't have
Your
to.
Honor, I am not unwell
You are
indefinitely.
kindly listen to the court. You are not
Yes, Your
required
Honor.
to bear any expenses. We'll direct the competent authorities to engage a lawyer free of cost.
I
So
would like
that
to,
you can look after your health and look after your child, and you did not bother appearing before the court through VC or in person unless otherwise directed by the court.
Your Honor, I would like to decline the offer. I have had a court-appointed advocate before, appointed by this very court. And the advocate did not do according to the benefit of his client. So I have decided that I will go ahead and do this case myself to the end. I'm
Yes.
not asking for a very big thing, only just a few weeks for recovery, Your Honor. That's all. And in order to file the rejoinder, Your Honor.
All right. Heard. MS so-and-so, petitioner in person. Mr. Counsel, do you have anything to offer, submit?
Yeah, I beg to submit one, I want to mention, my lord,
Yes,
there is an order dated 18/2/2022 on the writ petition, 18/2/2022.
yes.
Last paragraph, my lord, page number 6,
18,
18/2/2022.
yes,
Last paragraph, I shall continue to provide the present treatment being meted out to the said child. The entitlement of the respondent one to the amount as claimed in the legal notice, as well as the treatment meted out to the child of the petitioner, shall be considered on the returnable date. It is an order operating portion, my lord.
yes,
We are scrupulously following that instruction from the High Court.
that's good.
But I want to mention it is more than 3 years, my lord.
Hmm.
In the civil side, we are not able to claim any bill from the client because of this order. My lord, it was
Have
an
you-
interim
Have you
direction.
filed any
Then,
application seeking vacation? Modification of this order?
yes, my lord, I want a modification because it is prolonging.
You have to file a proper application, Mr. Counsel.
Yes, lord, I will file. Much obliged.
Yes. Heard. MS so-and-so, Leonard, counsel for petitioner in person who has appeared through BC and has reiterated a prayer seeking accommodation on account of ill health. However, no such medical documents have been placed before the court in support of our contentions, seeking an adjournment. Stop. This writ petition was directed against the hospital, namely so-and-so, seeking appropriate orders on the ground that the procedure undertaken during the child delivery resulted in some injuries sustained by the newborn baby of the petitioner and leading to disablement of the child who is still under treatment in the same hospital. Stop. In terms of the earlier order dated 18/2/2022, the hospital has been directed to provide medical treatment to the child, and the same has been done. Better. An IA was filed, being IA number 65, by which the petitioner in person had made some allegations against the counsel who had earlier represented her and has therefore sought for hearing the counsel as one of the respondents. An order passed by this court has arranged, on the basis of the application, an order passed by this court has arranged the counsel, namely so-and-so, as respondent number
7, Lordship.
7. Stop.
To file objection, Lordship.
Respondent 7 is present in court in person. Stop. You have filed objections?
Yes, Lordship, recording. With evidence, Lordship.
In the IA. She therefore submits that this IA has been filed with malafide intention and with his full intent, not with notwithstanding the professional help which the respondent number 7 in person claims to have offered to the petitioner in person when they approached her for rendering service. Stop. Be it as it may, the petitioner in person has repeatedly prayed for adjournment on the ground of medical health illness of the petitioner herself. On the last occasion, the petitioner was asked to apprise the court in terms of apprise the court about the status of her health. Stop. Today, the petitioner again addresses the court through the sea and renews a prayer for adjournment for 4 weeks on the ground that she is suffering from ill health. Stop. However, no documents, no medical documents, statements and prayer has been placed before.
Your Honor, if I may, I do have the documents right here, but since
Have you placed it before the court?
since
You
I
don't have-
wasn't able to physically attend the court and virtual
You can file it by,
e-services is not available
you are entitled to
But I
file
don't-
an email in the
by
court.
email. Okay, Your Honor, I will do
However,
that.
she takes liberty to place these documents by the next date fixed, either physically or by filing necessary email at the registry of the court. Stop. Considering the pleadings before the court, more particularly in IN number so and so, as well as the prayers made by the petitioner in person, seeking relief against the respondent number 7 in person for deficiency in rendering professional service, and also noting and also having noticed that a complaint has also been filed against the respondent number 7 in person by the petitioner before the bar council of so and so so and so
With similar prayers,
with similar prayers. Comma. This court is of the view that you write one more. In spite of the offer made by the court of free legal aid counsel to represent the petitioner without having to pay any expenses, so that the petitioner may be properly guided in terms of the law as per the procedure required to be followed in court. The petitioner has declined the offer made and insists that she would like to present her case in person before this court. So under such circumstances, taking into consideration the repeated prayer made by the petitioner for adjournment, the matter stands deferred to be listed after 8 weeks on a date to be fixed by the registry. Stop. Meanwhile, in respect of the complaint number so and so dated so and so, filed before the bar council of so and so, it is directed that if the proceedings are conducted by the bar council, then no further orders be passed without leave of this court. Stop. Vera, Mr. Your name, please?
Samuel Abraham, my lord, Samuel Abraham.
Mr. Samuel Abraham, learned counsel representing the hospital, respondent number so and so, is permitted to file their counter affidavit / objections in the IA in the meantime. List accordingly. It is, you make one more, take it that, it is made clear that until such orders are passed by the Bar Council of India with leave of the court, there shall be no impediment in the respondent number 7 to render her services as a advocate of this court and pursue her profession. Yes,
Much obliged.
list after 8 weeks.
Item number 17.
Thank you, Your Honor.
Yes.
What should I file an IA for leave to amend the plate? Amend the petition.
Okay,
Straight, coming straight to the point. We take your lordship to the writ petition first.
okay.
And to be fair, at page 27,
27.
27, yes. 27, the bottom of the page. Page 27. The Russian court, page 27.
Yes,
The bottom of the page, where A, Washington set aside, dated in 3/3/10, regularizing the service of the number 3 and assistant manager. So, your worship, in the NIDC, they have service rules. Appointment to the service is only through resolution. There is no regularization of service. So that is the basic, that is the foundation of the private respondents entry into service in the NIDC. And where to? Worship, where to? Order number such dated 16/8/2012, appointing the respondent number 3 to the post of deputy manager. Now, this order, I can take a lordship of this order. Page 145.
yes,
45. This is an order dated 16 August 2012. In the interest of the corporation, as approved by the board of directors, may probably kindly know the language. As approved by the board of directors in its 185th meeting held on August 13, 2012, the management is pleased to appoint Shri Tunjanyanga Javid to the post of deputy manager against existing vacancy in the pay band of such and such, plus all other announcements as are admissible under the rules in force from time to time, with effect from the date of the charge. Now, Your Worship, this is the reason why I have filed the amendment application. This order is based on the decision of the board of directors. The state respondents have filed their affidavit petition. The private respondent has filed his affidavit petition. The private respondent does not take the ground that I have not challenged the decision of the board of directors. It is mentioned here. It is my case that it emerges between some. The state respondents, they have taken the ground that I have not challenged the decision, and which is the decision of the board of directors in its 185th meeting.
yes.
So I want to rectify that, just as a measure of abundant caution. That is my case, it is I.
So is there any objection?
Yes. And so the objection, Your Worship,
What is
the
that objection?
objection has been filed by the state as well as the prime respondent. The objection is on merits.
No, what is the objection?
Okay, yes.
Lordship. Lordship, now the issue relates to the petitioners. Just.
You're for the selected candidate.
Yes, I'm for the mother, both the petitioners and respondents are presently serving as general managers. The highest, second highest position in the department. Now in ITC, Lordship is a corporation with a board of directors under the Companies Act. And Lordship, all as per the rules, all decision has to be with the prayer of the final approval of the board of directors. Now, my lord, the issue is basically a seniority dispute between the petitioners, great petitioner, respondent, number 3, and the grade of general petitioner. Now, my lord, I belong to the marketing wing. Petitioner belongs to the legal wing. You were initially appointed as assistant manager. The convergence in the grade of assistant general manager, and then seniority is maintained. Now, seniority is challenged. The petitioner is disputing the seniority. Now seniority is fixed on the basis of merit in the department. Now, my lord, however, the writ petitioner has challenged this one prior before this honorable court. It was struck off my name from the service rule itself. My initial appointment as assistant manager, deputy manager, everything has been challenged here. Now the issue relates to the grade of deputy manager now. Now, notice you can see that the writ petition, we file our affidavit in opposition.
Yes.
Further, we file our respondent number 1 and 2 has filed affidavit in opposition on 18/3/2024. Lordship, you can see the timeline. Then thereafter, Lordship, a reply affidavit was filed by the writ petitioner on 11/6/2024. And Lordship, the respondent number 3 also filed my affidavit in opposition on 21/9/2023. And affidavit in reply was filed by the writ petitioner on 19/1/2024. In between the filing of the affidavit in opposition and filing of the reply, the case was listed for about 5 times. In between. And rule was issued thereafter. Now, my lord, the issue is this. Lordship, the rate for this honorable court. Lordship, may kindly allow me to save time, Lordship, can you allow me to refer a paragraph? My lord, Lordship, may kindly, to save time, Lordship, in the affidavit in opposition of respondent number 1 and 2 at page 25.
Yes.
Lordship, 33.4 at page 25.
Yes.
Even otherwise, also for the sake of argument, the defendant also basically respectfully states it submits that the basic order, that is the approval of the appointment of respondent number 3 by the board of directors in 185 meeting dated such and such has not been sealed. To this, an affidavit in reply has been filed
By?
by the petitioner.
Okay.
As early as Lordship, as early as 11/6/2024, Lordship, you can see this affidavit in reply at page 15.
Yes.
Page 15, paragraph 21.
Yes.
That the statements made in paragraph 32.4 of the affidavit in opposition are misleading and liable to be rejected. Petitioner has rightfully challenged order dated such and such, appointing the respondent number 2 to the post of deputy manager. As such, the inference that a legal appointment of respondent can be protected by decision of the POD making held in such and such and resolution such and such is mere legal sophistry and untenable. Oh, the statement is in this paragraph also negates a claim of the alternative remedy set by the respondent in respondents number 1 and 2. Now, my lord, in my affidavit, in paragraph, my lord, in paragraph, just to save time, I will only mention paragraph 5, and paragraph 11 on my affidavit in opposition of respondent number 3, I have taken a specific ground that the petitioner has no grievance over the regularization in appointment of the respondent number 3. To that, the petitioner has filed an affidavit in reply, wherein he says he took a stand that reply in paragraph. My lord, responded in paragraph 7, 9, he took a stand that not challenging the basic order, not agreeing is nothing but legal sophistry and fanciful. Now the issue is this, Lordship. Lordship in the present IA, Lordship may kindly see the IA. The present IA.
Is there any interim order?
There is an interim order. The issue is this, Lordship.
No, what is the ground for objection?
My lord, I am coming to that. The ground for objection is that, my lord. My lord, the writ petitioner in his affidavit in reply has taken a specific stand. Now there is no, however, my lord, in the present writ petition, in the present IA, there is no prayer for amendment of the affidavit in reply. The prayer is only to amend the writ petition. And order 17 rule 1 lordship is aware, written statements, affidavit and replies are also part of the pleadings. So when there is no prayer, then he has already taken a stand by filing his affidavit in reply, lordship, where he has taken a categorical stand that it is not necessary to challenge. Isn't that the case where I have also established a legal position to take a ground that without challenging the basic order, the consequential, without challenging the basic order, the consequential order cannot be challenged. My lord, that is a legal right I have established. If the petitioner has approached this honorable court for amendment without filing his affidavit in reply. Now, my lord, and in the present IA, there is no prayer for amendment of the affidavit in reply. So this IA will remain, the pleadings will remain.
See, subject to what you say. If you come to page 30 of the writ petition.
$28.
30.
Okay. Yes.
This is the standard prayer you find in all writ petitions. Pass any other appropriate orders. Now in a writ court, strictly speaking, we are not bound by the principles of CPC. Now the only thing is that, as you know, the provisions of order 6,
Yes.
it can be amended at any time
No,
prior to the conclusion of
the issue
hearing.
is this. I have no problem with that submission,
Right.
that opinion. The only ground I'm taking is that at any stage, yes, but my lord here, he has already filed
Does it
an affidavit in reply.
does it change the nature of the
Yes,
case?
yes,
How?
it will change it, because my lord, I have already established a legal position that since the basic order is not challenged, the constitutional order cannot be challenged. So if that position is changed, then irretrievable,
That can always be,
damage will be appropriate.
no, that can always be taken care of by the court during the proceedings.
Another issue.
It is only perhaps to the benefit of the respondents that he is confronting you with his challenge.
My lord, the issue is this. What about if, my lord, the position is, if in his IA, besides the prayer for amendment, after by adding certain paragraphs, if there was a, by amending besides the prayer for amendment of the writ petition, if there was also a prayer for amendment of his affidavit in reply, and that would have a different issue. But the fact remains that there's no prayer for amendment of the statement in his affidavit in reply. It will remain.
That comes subsequent to
My
your not objecting to the prayer for
So
amendment.
that is why, because so that is how, my lord, then what happens? Because that will remain. There's no prayer for amendment of that, because is already there.
That's for him to decide how he wants to deal with it, and the court, as and when the court
Well, that
addresses
is
the
why-
pleading. But the basic question is an amendment otherwise required to be turned down, merely because the pleadings have been exchanged?
My lord.
If you follow the spirit of CPC, it can be amended at any time
No,
prior to
no,
hearing.
Because the only objection I'm raising is because he has already taken a categorical stand in his reply affidavits. And there is no prayer as of today for amendment of that particular paragraph in his affidavit in reply. So since there is no prayer for amendment, as
Well-
on today it is, and then it's finally.
If it pleases you, then we'll direct him to amend the reply also. Appropriately.
I'm going by his prayer. I'm going by his prayer. I cannot go beyond the prayer.
Your Lordship, there is a point which I would like to make, which I was making earlier. Not challenging the basic order is the respondent number 1 and 2's argument, not his argument.
No, my lord.
He is saying,
Paragraph 11.
he is saying, that I have no locus standi because he belongs to the management stream and I'm in the legal stream. That's his stand.
My lord, in paragraph.
And all these arguments, Your Lordship.
Paragraph 11, I can show. I can show.
All these arguments which my.
I can show. I can show from the paragraph.
These are merits, Your Lordship.
But going by the
Yes.
law of this court as well as the apex court, it have to be liberally construed.
My respectful submission, I live with your lordship, my respectful submission is my lord, subject to the lordship's decision, that is that. My lord is that since he has not prayed, since he has already taken a position, because my lord, lordship, I can appreciate this, after he filed his affidavit in.
What is that exact stand he has taken in the reply
Lordship, I have just shown the lordship,
of reply to 1 and 2,
yes.
page number?
One, my lord, which? Yes. My lord, page number 15, paragraph 21.
Of the reply affidavit to
Yes.
affidavit by 1 and 2,
Yes,
page number 15.
15, paragraph, page 21,
Hmm.
paragraph 21.
He does not, it probably does not mean.
Not in the analysis, statement 3.4, 3.4, what is the condition of reply in of respondent number 1 and 2? Page 25, 33.4.
Yes. That it has not been challenged.
Yes.
So the reply subject,
Subsequently, the affidavit and opposition are misleading and liable to be rejected.
Hmm.
The petitioner has rightfully challenged the order such and such. Yes. And lordship beginning as such an inference of the legal appointment of respondent 3 can be protected by the decision of the board of directors on 111 meeting. It is thus and judge the execution is mere legal sophistry in content of law. So he has taken a stand on this. This is specific reply to when the reply to 33.4, which says that
he does not submit or he does not contend that he is going to challenge it. He does not contend from this paragraph, subject to correction, that the challenge to this particular is not necessary. Just giving a reply.
You can say that if motion is the first line.
Misleading,
Convention is liable to be rejected. That means it is unless, that is the issue.
right?
The first line.
But where is the authority to say that he cannot now turn around and pray for
My
him?
only, I need to be lordship,
Ah.
my only objection is that, my lord, what happens to his amendment, to his affidavit in reply, because that has attained its finality as from today.
Which is not attain finality. It will attain finality when an order is passed by the court.
With regard to his affidavit, I'm saying.
That's right. That is his stand. It may be accepted, may not be accepted by the court, ultimately. The only question is that he wants to formally bring a challenge to this particular order which he wants. Unless you agree that during the course of the hearing, there's no bar for the court to decide on this issue.
The issue is this. We file it, then he filed his reply, then matter was listed 5 times. On all
No,
these
you're-
5 occasions, he remained silent.
You're right.
In this belated stage, he
I-
wants to amend. So this
I-
aspect of the matter, by the lapse of time, because this is an issue, by the lapse of time, that is when the motion is well, by the lapse of time, I have Then you establish a legal position, though argues that the sea order is not challenged. Legal right is different from legal position, right? And that is a legal right. Under the law, that is a right that I can find. Can I place to authority? Or is it not necessary?
If you want, you can place, but ordinarily, order 6 is to be,
Ordinarily, I'm well aware about the,
That's
but
right.
only this issues I bring to your lordship. Lordship has, you will take the final decision, but it's my fountain, you need to bring to your lordship. This is my submission, I live, the rest I live.
yeah, I would appreciate a hearing in the merits of the matter.
Yes.
But in case of an amendment, I don't think,
I live it is my fountain duty, since I'm defending my client, it is my duty to protect.
do you have any authority to
Yes.
support your submissions? Do you have any, are you pressing any authority on this?
No, but. But the law is very clear, because when certain legal rights has been approved. But
The what right?
my lord, my right to defend, to say that the basic order, my basic order has not been.
That's an objection. You are entitled to take it.
Yes, but if amendment is allowed, then that right will be deprived to me, that submission will be deprived to me, that is what I'm saying.
Then-
Which will cause irretrievable
Then-
prejudice.
Then perhaps you may like to take the ground that even notwithstanding the challenge, your legal rights are not affected.
My lord, because the issue is, my lord, your lordship may kindly appreciate this fact. That the situation I'm in, he wants to remove me from service.
Therefore,
And
therefore,
if
therefore,
this,
therefore, I'm asking you, are you placing any authorities? Or if you want the matter to be taken up tomorrow, then
this is your lordship, but this is my submission.
Okay.
My objection is recorded.
all right, I'll do that.
Lordship, by the amendment, I pay for the paragraph 5.
In the IA.
Yes.
Is there any objection filed to the amendment? Yes,
Yes.
yeah, okay. Objection filed by,
Both,
huh?
both, in response 1 and 2, as well as there's 1 and 3.
Only one is available here.
1 and 2.
Huh?
Oh,
You have not filed.
here.
No objection filed, yes. Okay, heard. Mr. Zimomi, learned counsel for the applicant writ petitioner. Mr. Airalu, Takamasa, sorry. Then at senior counsel assisted by Mr. Appearing for the respondent number 3,
Mr. Kiralo,
Mr. So and so for respondent number 1 and 2. Stop this IA has been filed, praying for amendment of the writ petition. And seeking inclusion of a prayer. Only the prayer, inclusion of a new paragraph and amendment of the prayer. Stop. Where the challenge made in the writ petition is with regard to the seniority,
appointment of the respondent 3 and consequent seniority.
appointment of respondent number 3 and the consequential seniority. Stop. Both the petitioner and the private respondent are employees of NIDC.
Yes.
And are working as jail managers. Stop. In the writ petition, the petitioner has made the following prayers, page 27, 28, 29, 30. Extract. Para. General counsel for the applicant submits that in response to the writ petition filed by the petitioner, in the counter affidavit filed by the respondents number 1 and 2, an objection was raised that an averment was made that the order dated. What is that order?
The board of directors, decision of the board of directors in its on executive meeting
Hmm.
and updated 2012.
No. Consequent to that, which order was passed? 16.8. 16.8.
Yes.
The order number so and so dated 16/8/2012, page number 28, appointing the respondent number 3 to the post of the deputy manager was made pursuant to the 138 meeting, 135th, 185th meeting of the Board of Directors of NIDC held on 13/8/12. Stop. Since the challenge is made to the consequential order appointing the private respondent, the respondents 1 and 2 objected that the order which resulted in the consequential order giving appointment to the respondent 3, namely the 185th meeting of the Board of Directors, the NIDC held on so and so, is not under challenge. Stop. Where pursuant to the averment made, pursuant to the affidavit being filed by the respondent 1 and 2, containing inter alia, the said averment, the petitioner has filed this application seeking amendment of the writ petition with the following amendments. You extract the amendment from para 5, page number 5, para 5, so 1, Roman 1, Roman 2. Para. Notice in the matter was issued on 30/09/2024. Pursuant to the notice being issued, the respondent number 3 has filed its objection opposing the prayer for amendment of the writ petition. Stop. Learned Senior Counsel appearing on behalf of the opposite party respondent number 3 strenuously argue that the petitioner has waived his right seeking an amendment in view of the stand taken by the petitioner in the affidavit in reply filed by the petitioner to the affidavit filed by the respondent number 1 and 2, referring to para 21 of the reply affidavit filed by the petitioner to the affidavit filed by respondent 1 and 2, learned counsel for the petitioner, referring to the opening lines in the paragraph, submits that the petitioner contended that the petitioner has made the averment that within quotes, the statements made in paragraph 33.4 of the affidavit in opposition are misleading and liable to be rejected, quotes closed. So referring to this paragraph, learned senior counsel has strongly objected to the prayer made in the IA seeking amendment. Stop, he submits.
Sorry, I'm also making a suggestion that there is no foundation for amendment in the petition. Yes,
That he submits that there is no valid ground seeking an amendment at this stage of the matter when all the pleadings are completed and the matter is ripe for hearing. Stop. He further submits that the prayer in the IA is seeking amendment of the writ petition, but there is no prayer seeking amendment of the affidavit in reply filed by the petitioner to the affidavit in opposition filed by respondents 1 and 2. Under such circumstances, he submits that the IA should be rejected and the prayer for amendment should be declined by this court, and the writ petition should be heard in its present frame. Stop. Well, learned counsels have been heard. The IA, along with the objections filed, as well as the pleadings available in the writ petition, as referred to by the counsels of the bar, have been carefully perused. So, although strictly speaking, the Civil Procedure Code is not applicable in its strictest terms to proceedings under the writ petition under 226 of the Constitution of India. Nevertheless, the spirit of CPC is required to be applied to store. Under Order 6, Rule 7, 17. It provides, of the CPC provides for amendment of the claims. Stop. The consistent view of this court as well as the apex court is that this provision seeking amendment should be, to the extent possible, be considered and allowed, with the only exception that it does not change the nature of the suit or the litigation. So, where in the present proceedings, the challenge is made to the appointment order dated so and so, whereby the private respondent number so and so was appointed as general manager under NITC.
Assistant manager and deputy manager.
Not general manager.
Beginning from the entry to service. Assistant manager,
Okay,
followed by
was appointed as assistant manager and subsequently as deputy manager. Stop. These orders were passed by pursuant to decisions taken by the board of directors, which admittedly has not been assailed in the present proceedings, and therefore the application seeking amendment has been filed. Stop. Whether without putting to challenge the orders of the board of directors, effective orders can be passed by the court in the event the court finds merit in the contentions of the writ petitioner and thereby seeks to interfere with the orders of appointment and / promotion of the respondent number 3, is to be decided by the court upon final hearing of the matter. So, in any event, there is always an inherent power of the court to mold the prayers and the relief sought for, so that substantial justice can be meted out to the litigants before the court. So, under such circumstances, this court is of the view that, considering the principle culled out in the various judgments rendered by this court as well as by the apex court, applications seeking amendment under Order 6, Rule 17 can be permitted before matter is finally heard, subject, of course, to the exception that it does not change the nature of the suit or the pleadings or the proceedings. So, in the facts of the present case, at this stage, allowing the IA in the considered view of the court will not have the effect of changing the nature of the proceedings. Stop. The appointment / promotion orders of the respondent number 3 have already been assailed, and it is open to a court at the time of hearing to call for the relevant reports, then examine the matter and thereafter pass appropriate orders as deemed fit and proper. Non-challenge to the order dated so and so may not in all cases prevent the court from rendering substantial justice. Under such circumstances, the prayer for amendment to amend the petition as sought for will not change the nature and structure of the present proceedings. The objections raised by the respondents are overruled. Stop. The IA therefore stands allowed. The petitioner is permitted to bring in the necessary amendments within a period of 10 days from today. Stop. The amended writ petitions will be served accordingly within a period of 10 days on the respondents. Stop. The respondents are also at liberty to file additional counter affidavits countering the amendments brought in if they are so advised. Stop. IA accordingly stands allowed and disposed of. Next, you write in the writ petition, in view of the order passed today in IA number so and so, the amendment prayed for is allowed. Petitioner is to file amended petition within a period of 10 days from today and serve prior copies of the amended petition to the counsels appearing for the respondent 1, 2, and 3. Matter be listed again.
The liberty to file additional, as mentioned, the kind be mentioned in the main petition also.
Respondents are at liberty to file the additional affidavit if so advised. The amendments brought in. Yes, interim orders passed earlier will continue. You're not filing vacating petitions. Have you filed any vacating? They continue until further orders. Why extend it day-to-day basis?
From supply cost list, admission item number 33.
Supply. Where is the supply? Yes.
It's a matter of, I've been recently appointed as a senior standing counsel for the Department of the Respondents.
Yes.
And I'm yet to receive the briefs.
I was told one Mr. Mishra IPS here in the matter.
Yes, it was a special counsel.
Then?
Recently, I've been appointed as a standing.
When?
A month ago.
We passed the order on 7/11. We are informed that Mr. Mishra is the standing counsel.
No, it was a special counsel.
Yes.
On the last patient lordship side, just to contact Mr. PK Mishra. On contacting him, he informed me that, asked that, he has been disengaged by the department and yet.
To ask him to hand over the files immediately. Why is he sitting over?
Yes, sir.
Why is he not handed over files?
It's in the process, sir. The department has informed me that they will, this time they will be handing over the briefs to us.
What is your prayer here?
I'm seeking some time.
First, let us understand what is your prayer. You're challenging this order.
Lordship, the petitioner is there. Praise that lordship, the respondents have laid it twice, the text GST to goods text.
But there is an appellate forum. Why don't you go and appeal?
No.
There is an appellate forum under the GST Act.
No.
You can go and file an appeal.
What should be so what is the jurisdiction to where?
We have, but we don't want to, and because there is an alternative forum under the Act. So ordinarily, you should explain why that forum is not sufficient for you. And why we should exercise our jurisdiction.
Lordship seems to be contract for was in Kohima, in Nagaland. for purchase to go project.
No, no, no. Where is your appellate forum? Where is the appellate authority? This is for the state of Nagaland, isn't it? GST.
Yes.
You have an appellate forum. Where is the impugned order? See, you come to page number 29. This is the order you're challenging. Do you have a copy of the petition?
Since here the legal counsel is inserted, okay,
You can read it, even if the council is not here. Read the order. Do you have a copy? You don't have the copy. You take out page number 29. Is there a second file here, Court Master? Yes. Give it to the standing counsel. Yes, you take out page 29. This is the order you're challenging, isn't it? You read the paragraph 2.
Any person being himself paid by any institution for other cost of energy, see GST Act law for the as GST Act indicates it to the commissioner. Use the floor.
See, that's the appellate forum. Commissioner appeals and joint commissioner appeals. The order itself reflects that you can go in appeal. But you have come before the court, why?
For instance, this matter has been by Mr.
You talk to the arguing counsel and come back tomorrow.
Not
Tell him, ask him, what is the,
regarding the articles.
yes, because see, you read para 25, page 25, para 21 of your writ petition. Huh? You got it? Para 21, page 25.
The base, it's not other adequate.
Ah. You have made a statement, and this is sworn in the affidavit to be true to your knowledge. This is not a correct statement. This amounts to a false affidavit sworn before a court. You get the instructions, there is an appellate forum, go before the appellate forum. All right? We can't give you the file tomorrow, you get your file. Okay. Tomorrow is Tuesday. Then we'll have it on Wednesday, after DB. After rising of DB.
Particularly then the meeting should continue.
All right, interim orders will continue even if we don't pass any order. Mr.
Is that
So-and-so appears as the appears before the court and submits that he will represent the GST department,
all the respondents?
all the respondents. However, he is not posted with the required instructions and prays for time to complete his instructions. Mr. Fode, learned counsel, submits that Dr. A. Toby is the arguing counsel who is not present before the court today. Stop. The impugned order dated so-and-so reflects that there is an appellate forum for filing an appeal against the order which is impugned. Stop. Learned counsel for the petitioner will apprise the court as to why the petitioner should not be relegated to approach the statutory forum prescribed. Council prays for time, matter to be listed on Wednesday, to be taken up after rising of the DB. Interim orders, if any, will continue until the next date.
For orders, item number 34.
Roughly, I don't have. Yeah.
My lord, may I
Yes.
please?
Yes,
My lord, I am sorry I could not come physically, lordship, due to some health issues in my residence.
your digital appearance is good enough.
My lord, I am obliged, my lord. My lord, in this case, my lord, we have not filed affidavit as of now, but I received the parawise comments, lordship. So some
What is the fire here?
lordship, they have challenged, my lord, the impugned order of assessment, my lord. That was passed under section 147 of the Income Tax Act, read with 144, my lord. In fact, that order was already been challenged before the appellate authority, my lord. They have stated in paragraph 13 of their writ petition, my lord. Page 14, which they have also annexed, my lord, as annexure 9 at page 67, my lord.
What happened in this case is that assessment order was passed against me, demand notice was issued. I've been given time to appeal, so I have filed my appeal before the Commissioner of Income Tax Appeal. But during the pendency of the appeal, lordship, penalty notice was reissued against me. Also demand and area notice was issued against me. So I have no choice, lordship, but to approach this court. Lordship,
What is the stage of the appeal?
lordship, it's still pending, lordship. It's still pending. I have filed Form 35.
It's a faceless appeal.
Yes, lordship. Lordship. So during the pendency, lordship, if you kindly come to page number 74, lordship. 74 and 75. This is the penalty notice. And lordship, page number 76 is the demand in areas, lordship.
Yes. So there is an interim order.
There's an interim order, lordship, in this.
You're not challenging the initiation of proceedings under 147, is it?
Oh, lordship, I'm also challenging that under this petition, lordship, because I have.
They have already completed the assessments.
Yes, lordship, they have completed. That is why I have filed my appeal, but during the pendency, these two notices were issued, lordship.
You don't enforce the notice, don't enforce the penalty till disposal of the appeal.
My lord. Lordship.
Since the appeal is already pending.
Yes, lord.
So the penalty will be subject to the such orders passed by the appellate authority.
Yes, lordship.
Mr. Setia,
My lord.
what do you say?
My lord, in fact, the appeal is pending, and my lord, the appropriate authority is the, my lord, appellate authority to pass necessary orders, my lord.
We are not denying it, lordship.
But she is apprehensive of the demand you made. Appellate authority has not stated the demand.
My lord. Yes, my
Yes.
lord. That was not stated.
And have you paid, how much is to be paid? 30%, 25%?
I think, my lord, it's 20%, my lord. As a, my lord, the
Have you
appeal.
paid that amount?
No, lordship, because after filing the appeal, there is no notice, lordship, no direction from the appellate authority, lordship.
Do you have the Income Tax Act?
Yes, I have the act, lordship.
See the act. There is a requirement to pre-deposit the assessed amount. Mr. Setia?
My lord. Section 256, lord.
256.
Lord, section 250, my lord.
Exactly, lordship. I'm not covered under section 147 or 148, lordship, because.
That the appellate authority will decide.
Yes, lordship. And also the assessment was also wrongly made, lordship. responded to the show cause notice. Whereas I have sought for time, Lordship, to furnish necessary details that have been asking, Lordship. But then, Lordship, if you see the notice that was issued against me, another notice under section 148 was issued on 31st March 2020.
After completion of the assessment.
No, Lordship. If you would kindly allow me to advise you, Lordship, it's in
Yes.
page number 46. Notice under section 4148 of the income tax, Lordship. This was issued on 31st of March 2024 or 21, Lordship.
Yes.
Then, yes, Lordship. Then the assessment order was issued subsequently, Lordship. Now, since it's faceless, the documents that I've, yes, I admit that there has been some lapses from my end because, Lordship, I'm not familiar with very new to this, Lordship, the faceless system. Which, but I have responded to the show cause notice. I sought some time to allow me to furnish the documents, Lordship. So, Lordship, the allegation that was made was that I have deposited more than 2 crore in my account, whereas the bank declaration is clear, Lordship. I have only deposited 10 lakhs, Lordship.
That is what we wanted to know.
Yes, Lordship. Because I'm not an SSC, as defined under section 27 of the ITA, Lordship. I'm exempted, Lordship, under section 1026.
That as on date is slightly late because their assessment has already been completed. You have gone in appeal before the authority.
Lordship.
So for this court to today render any finding, would be subject to such orders that you can challenge after the order of the appellate authority.
Yes, Your Lordship. In fact, I was waiting, Lordship, for the instruction and also to submit my written argument. I was waiting for that. But these 2 notices, penalty notice, and then a demand in area notice was issued.
Mr. Setia,
Lordship.
do you have any instructions when the appeal is likely to be disposed of?
My lord, that instruction, my lord, I don't have at the moment, my lord.
So why don't we close the petition that the demand notices, since the matter is pending before the appeal,
My lord.
and the petitioner has also paid the statutory dues, this shall not be given effect to until the appeal is disposed of.
Lordship, my lord, it may be, my lord, subject to the, my lord, order passed by the appellate authority, Lordship.
That's what we said.
My lord, my lord.
Then we can close it.
Lordship.
Yes, madam.
Yes, Lordship. Then in that case, Lordship, allow me to kindly submit my written argument before the appellate authority.
You submit whatever you want to submit. You
Yes,
don't need
Lordship.
permission from the court. Your
Okay,
appeal is
then,
already
since-
pending.
Lordship, yes, since it's online proceeding, Lordship, you need to set a slot for me.
We don't know that. You approach the department and find out if what arguments or whatever they require. If it is faceless, I don't know if there is a provision for furnishing arguments. They will call for the record.
There is, Lordship, there
There
is.
is, then you
Yes.
furnish it.
Lordship, then if you would kindly reflect your order to allow me time, Lordship, to submit my written arguments.
No, that we can't put it in the order unless you place some material before the court that the matter, or you had approached the authority, they have declined for submission of orders, written
It
argument.
was not declined. In fact, a few days back, I received one notice. But then since the matter is pending before this court, Lordship, that's why I could not submit it. So I have given my response accordingly.
Without the factual position, we can't pass an order like that. You have to tell us that there is a provision and the time has not expired for you to file it. That's all we can say.
Lordship, there is no time bar, Lordship.
We don't know. Don't know that. Because these are not available before us.
Lordship, can kindly give me some dates so that let me produce necessary documents, Lordship. The response that I've given.
No. We are disposing it off without expressing anything on the merit because you have already preferred an appeal.
Lordship.
And the appeal is pending before the authorities.
Yes.
You are aggrieved by the demand notice pursuant to the assessment order. That's it. That's all we find here because you have prayed for quashing the assessment order,
Yes, Lordship.
but you have already preferred an appeal.
Yes, Lordship, before the commissioner.
So why should the court exercise its jurisdiction?
Lordship, the issue is that the subsequent or penalty notice that I've pointed out, Lordship. These are a problem, Lordship, because I was given a deadline.
No,
I was given a deadline,
penalty,
Lordship.
penalty will take care of it. That it will be made subject to the orders passed by the appellate authority.
Lordship, yes. So now, Lordship, if you will kindly allow me to point it out to you.
Yes.
This is the ITO who has given the demand in area notice, Lordship. Page number 76 and 77.
Yes.
This is the problem, Lordship.
What is the
This is
problem?
why I'm here before this court.
What is the problem?
Lordship, this was issued by the ITO, Mapur.
Ah,
Then, Lordship, it's issued on 20th of
you're referring to page number
76 and 77.
76, 77.
Lordship.
Yes.
If you will kindly allow me to read, Lordship,
Yeah.
to Mr. So-and-so, assessment year 2015-16, dated 2010-2023, subject issue letter, demand in areas of rupees 5,28,13,970. As per details available on record and in department's database, the following income tax penalty demands are outstanding in your case as per details given. Lordship, these are the details. You are therefore requested to pay the aforementioned demand on or before 06/11/2023 and to furnish, upload a copy of challan evidencing the payment thereof. Please note that in case of failure to pay the outstanding demand within the stipulated date, you should be treated as an assessee in default, and necessary recovery measures as per provisions of the Income Tax Act 1961 shall be initiated against you. Lordship, I will agree with this, so I have no option but approach this alternative, Lordship.
That's right, but to hold this order to be bad in law, this is the sequel order. This is the sequel of the order of assessment passed.
Lordship.
So your order of assessment will have to be challenged, which you are challenging before the appellate authority.
Yes, Lordship, that is why, Lordship. Now, if physical hearing is taking place, then I could have gone. In fact, I have also made an attempt to approach income tax office, Lordship, but they said everything is now faceless.
That's right. Everything is faceless.
Yes,
What
Lordship.
is your problem with being faceless?
So I
Good for
have
you.
no issue with that, Lordship. I have no issue. That's why accordingly I have exercised my rights and I've appealed.
Lordship, may I submit, my lord?
Yes.
My lord, the assessment order that has already been challenged before the appellate authority. Now, my lord, the two parallel proceedings are not allowed, my lord. They have also challenged the same very order, my lord, before this honorable court. And my lord, the penalty order, that is the consequential order, my lord. My lord, when they challenge the original order, my lord, they may also challenge this penalty order before the, my lord, appellate authority, my lord. That would be the, my lord, appropriate forum, my lord.
Yeah, you find out and let us know whether the both the orders are challenged before the authorities or not.
Lordship.
Because once the matter is pending before the appellate authority,
My lord.
the appellate authority is seen of the matter, they can pass some orders.
Yes, lordship. Yes, lordship. So, my lord, some time may be granted, lordship. I'll have the instruction.
Have it by day after Wednesday.
Lordship.
You have to only get the instructions whether any orders have been passed.
My lord.
So
Wednesday, lordship.
Wednesday.
Lordship.
Third, learned counsels for the parties. Learned standing counsel income tax will apprise the court as to the status of the appeal stated to have been filed by the petitioner challenging the assessment order dated 31/03/2022, along with computation order dated 31/3/2022 under section 147, read with 144, as well as the connected demand order dated 31/3/2022. Stop. Let the instructions sought for be placed before the court on the next date fixed. You, Mr. Setia, you
Hello.
get the precise information as to what is under challenge.
My
What
lord,
the assessment order, and is it assessment order along with the demand notice?
lordship, lordship.
Because ordinarily assessment order itself furnishes, encloses the demand notice.
My lord,
And please give us any particular date if the appeal is fixed.
lordship, lordship.
Placed on Wednesday.
Thank you much.
Obliged.
For hearing, item number 19.
Yes,
Your presentation. I'm giving on behalf of my senior correspondent and again, you couldn't be able to give us out just now.
what is the matter?
The petitioners are very police personnel in Hidayat Palo on duty.
You are asking for compassionate appointment.
No.
Then?
Family friends.
Of family.
The problem was that the mother of the deceased, who's still alive, she was the nominee for other benefits, but the pensioner to go by the rule. That is the whole issue.
Now, who's, you're mentioning on whose behalf?
Accountant General,
Accountant General,
madam.
Mr. Muzoi,
No.
Joshua Sheki. When is he available to come?
On Mondays.
Why? Where is he gone? He was here last week. Yes, what do you say, Mr. Counsel?
Right.
Friday, no. Friday would be touch and go. Thursday we can have it.
Madam.
Will you inform him whether it can be taken up on Thursday? Prayer is made on behalf of the Standing Council for Accountant General, and it is submitted. The council is not available in court. Accordingly, as agreed to by the learned councils for the parties, it's again on 14th November.
Madam.
Item number 26.
Yes. Yes.
This at the time of the court, I will just give my information.
You want the regular scale of pay?
Yes, Lordship.
You are,
Let us start over.
you are working as a contingency employee.
Yes,
You are
Lordship.
not regularized.
Yes, initially he was appointed at a fixed fee of rupees 1,500. And then, well. she
No,
was-
but you are not regularized.
Yes, Lordship. Yes.
Yes, okay.
Your Lordship, this is a government case, which I've annexed in my annexure 5, page 17, Lordship.
Page 17.
Yes.
What do you say? Who's for the respondent? What do you say?
And during the ROP of 1993, there it permits your lordship. As far as the prayer is concerned, the lordship, the petitioner is praying for the latest ROP. Your lordship, the applicability, your lordship, it does not permit. So if your lordship allow me to please the latest notification, your lordship.
Yes,
The applicability clause, your lordship.
yes. Rule 2.
Rule 2.
We have a copy. Yes.
So your lordship,
What does it say? Please read. Please read.
your lordship, notification dated 16 December 2017, your lordship, in exercise of powers conferred by the proviso to Article 309 of the Constitution of India, the governor of Nagaland is pleased to make the following revised rules in supersession of the earlier notification. The lordship will to the applicability of the rules. These rules shall apply to all regular employees appointed to services or posts in connection with affairs of the state of Nagaland and which are under the rule-making powers of the governor of Nagaland. These rules shall not be applicable to all categories of work charge employees, person paid out of contingencies, person employed on contract, persons re-employed in government servants after retirement, and any other class or category of persons whom the government may by order specifically exclude from the operation of all or any provisions contained in these rules. So your lordship here, the rule 2, clause B, subclause 3, your lordship. The petitioner case falls under this category.
He's relying only on this judgment. You're relying on this judgment.
Yes, the judgment which he is relying on is a direction to dispose of the representation only.
Yes.
Yes.
He's relying on that. What is your prayer?
Your lordship, my prayer is that, since the petitioner is discharging the same duties as performed by the grade 4 employees, and then your lordship, the petitioner is praying, that since the similar situated employees who are appointed in the grade 4, since they are given the latest ROP lordship,
They are
and discharging the same duties.
No. They are getting it because they are regular employees. You are not a regular employee.
But then lordship, I bring based on the equal pay for equal work lordship.
That is not about.
Equal pay for equal work is provided your service is equal.
Your lordship, the your lordship, we kindly come to page 16.
Yes.
Your lordship, here as per the RBI,
Yes.
we are assuming as grade 4 in place.
No, but they're regular staff.
Yes, lordship.
They're regularly appointed. You are not regularly appointed. So you are referring to an order passed by coordinate bench.
Yes.
Where the direction is for disposal of the representation. Are you praying for a similar order or you're praying for deciding this issue?
Your lordship, pray for the similar.
Similar order?
Yes.
All right. Heard the council to the parties. Disposed. Council is referred to judgment. Where is that? Page number? Where is the order?
At page 17, lordship, an extra 5.
70. Disposed of in terms of page number 17 order. Huh? Very good. Yes. Disposed.
Much.
Give it to you.
Item number 27.
Yes,
This,
yes.
Lord, the first petition, the first petition was disposed of, by this honorable High Court. By speaking order to dispose the resignation to the appointed occupation fine. Now accordingly, Lord, the respondents by compliance letter dated 26 May 2023, next year, came
Yes,
intimated to the petitioners, to the petitioner, in fact, that my serial number is at 33. And also, my lord, they issued the impugned waiting list. However, on conclusion of the impugned waiting list, we have found some inconsistencies and some anomalies in the impugned waiting list. So I'm here challenging the impugned waiting list. And then, okay, not just that, the other issue is that, my lord, they have appointed persons on compassionate appointment who were not in the list, who were not even in the list of waiting list compiled by the department motion. So I'm here because of that motion. Now, if I may take you to the improvement list, I just want to indicate what are the inconsistencies and the anomalies.
yes.
Page, I think, page 34.
34.
Next year, key one. This
Yes.
was furnished me, this is the
Where is your name?
my name, my order says, 35 page, the next page.
35.
Yes,
Okay,
if I may take you to the first page, my lord. My lord, here.
Yes.
Serial number 1,
serial number 1.
yes, if I may indicate, my lord.
Yes.
Date of birth of the applicant is 1994,
Hmm.
and date of expiry, which is according number 6, is 2005. So when the applicant's father died, was only 9 years of age. He was a minor. And date of receipt of application, column number 7, 20/04/2023. So he applied after a gap of 17 years.
Right.
So he was a minor when his father died. Second of all, he applied after a gap of 17 years. That is serial number 1. And with regard to serial number 2, my lord, date of expiry is 2008, and date of receipt of application is 2016. After a gap of 8 years. And the next, my lord, date of birth is 2000, and date of expiry is 2011. Now, when the father died, it was only 11 years of age, and applied after a gap of 12 years. Serial number 3, my lord. His father died in 2013, and applied in 2016 after a gap.
Have you challenged their appointments?
I have not challenged the appointments.
No.
No, I'm challenging the waiting list, my lord. They are not appointed yet. They are in the list.
They're in the list.
You know, what I'm trying to impress upon the score is that, the intent and object of compassionate appointment is to give immediate relief to the family in distress. So now,
So this is only a waiting list.
this is the
They
waiting
will
list.
be subject to the scrutiny
Scrutiny.
and the parameters.
Yes,
They may or may not be appointed.
my lord.
But if you are saying that someone with these particulars have already been appointed, then you have to challenge their appointment.
No, my lord, they are in the waiting list. I'm aggrieved by the fact that the state respondents, the way they are maintaining the waiting list.
No, I think the waiting list is on the seniority of what? Death.
Yes.
Seniority of death.
Yes, yes.
So they are just maintaining it. Whoever is available, they will consider it.
My lord, but
Is it contrary to any office memorandum or anything like that?
it's, no limitation period is set in the office memorandum, neither in the addendum, however, keeping in mind the object and intent of commission requirement.
No, this is not pursuant to scrutiny. These cases of these persons have not been decided by the
Not yet.
department. So this is not a kind of a select list after scrutiny. So this is a case where they may or may not be considered.
That is true, my lord.
Mm.
But, my lord, if that is the case, and even in the affidavit in opposition, they have,
So
Yeah.
therefore, you have to challenge someone who, according to you, is situated like this, and not considering the delay also they have been appointed. You can challenge their appointment. We'll examine it.
that, my lord, but we do not have
Then,
that in this present case.
then,
So this is the first issue, my lord.
So you are only asking the waiting list to be set aside.
Yes, my lord.
That's on what
Yeah.
ground? On what ground? Is it contrary to any office memorandum?
My lord, immediately, my lord. The office memorandum does not specify the time limit.
Then,
That is, yeah.
no, not only time limit. That office memorandum shows that
The addendum,
uh,
that
uh,
has to be, there of chronology.
right, or
Yes.
something like that.
My lord, yeah, I'm coming to that, that is my second issue, my lord.
Mm.
The state respondents, the addendum and the office memorandum specifically says that it has to be serial wise, chronologically, right, my lord, but then, my lord. If I may take you, my lord, to annexure. Annexure. M. my lord.
Annexure M. Annexure M.
Yes, my lord, page 50. Next year, is page 48, the relevant. Next year, I want you to write my ones. At page 50. This is the first reading is here, my lord. If we compare this annexure M to annexure L3.
Yes.
From March 2018 till date, my lord.
Mm.
There has been 30 conventional appointments on you. And here, if we compare it to annexure M page 50 and annexure L3, my lord.
No, what are you trying to point out?
I'm trying to point out, my lord, serial number 4, 5, 7, 10, 16, 26.
Of page number 45, 47.
47.
What has happened to them?
These people have been appointed on commissioner grounds, but they do not appear in the commissioner waiting list.
So you challenge their appointment. You have not challenged their appointment.
Not just agreed by the waiting list.
No. You have to come before the court urging your right. You demonstrate that you have a right to be considered for appointment. But somebody else is appearing, at least not maintained, this is not a public interest litigation. You tell us that how the order rejecting your appointment is bad, we look into it.
Under this, I do not have a vested right to be appointed as a commissioner appointment, but then I'm just on the question.
That you are challenging somebody else's appointment on the ground that both of you are similarly situated, but they have been given undue advantage or they're appointed without following the requirements of the OM, then we can move into it. Nothing like that. So
That's in the list can be interfered.
no, it can't be interfered. No, we would not like to interfere with this. There is no basis to interfere. Why should we? Why should it be interfered with? You are unable to show that this waiting list is required to be prepared in terms of a set of guidelines or office memorandum or whatever. It's not there. They're preparing it. You are not challenging somebody's appointment on the ground that their names did not figure in the waiting list. You have to challenge their appointment. We can't direct. See, there's no negative equality. We can direct the court, direct the department that just as you have appointed so and so, you appoint the petition. That can't be done. All right, you want to withdraw or we dismiss it?
But if you can try it tomorrow.
Tomorrow? No, nothing is
There's one adjustment of coordination.
nothing is going to change. All right, tomorrow, at the request of learned counsel for the petitioner, learned government advocate appears. Please take tomorrow. You type up this order and give it to tomorrow's matter. So you have to sign it. Yes,
The question.
but tomorrow no adjournments.
Yes.
If you take adjournments, we'll discuss it.
I put.
Yes.
Item number 35.
Yes. For the family landowner,
Yes.
family of the landowner. Your claim is that you belong to the family of landowner
Yes, yes,
and you've been certified, but
Yes.
private respondent has been appointed.
yes.
Private respondent claims that he also belongs to the same clan.
No.
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 Okay. Private respondent says somebody else from your family has already been appointed.
That is what is.
Which is, so
Yes.
what do you say regarding that?
Your Lordship, the uncle of the petitioner, from the report, the uncle of the petitioner, his daughter was appointed. And then when the vacancy arose, again the uncle recommended his name for one as a landowner candidate. And he was appointed. Now, Your Lordship, prior to the 2018 notification, the scheduled practice was that landowners are entitled to all the appointments, but then 2018 notification came into effect.
Where is his appointment order? Where is your appointment order?
But it's page 22. It should be. This is the appointment order.
Okay.
And,
Where are the minutes of the meeting, madam? Municipal Commission minutes of the meeting, where is that?
Let's see if it's certain.
Annexure
And it's certain.
A. Yes, what does it say? Who is Nangshi Mayang?
No, Shivaya is the. It's from the petitioner on plan, not coming, it's under. The one who recommended appointment of the private respondent. European, agreement between the uncle and the.
He claims to be a landowner.
Yes, he is also a landowner.
Hmm.
We belong to the same land, we are all landowners.
So, pursuant to this, his daughter was appointed.
That is what the reports, the reporter is an election field.
Yes.
Actually, the mother is from a different village, Tampi village. So the petitioner has been staying there in that village as a daily wage earner. For all this time, with all these developments, petitioner has no
No, come to page number 22. This is the appointment order of the private respondent.
private response.
Now it refers to municipal council meeting minutes dated 11/7/2019. Where does one find it?
These minutes are not available. Only the.
Where are the minutes? Are they available with you?
No, I see.
Why? That is what we want to see. What did the municipal committee decided?
It's not that given.
Tomorrow? How many matters on Thursday? You have the diary? Huh? There's a diary. Yeah, you find out how many matters on 14. And on 13th? We'll have it on 13th. After rising of division bench. Right. Councils are agreed that matter be listed on 13th after rising of division bench. Council for the municipal council will place before the court the relevant records pertaining to the minutes of the meeting of the auction municipal council held on municipal council held on 11 June 2019, minutes number 2, whereby the private respondent was appointed as a chowkidar in a post vacated by late Samshir Guru, and whose appointment is presently assailed in the writ petition. List accordingly. Yes.
And project for this way. Every project, in I 2023, where on that I said, "Told you, Lordship, make any late moment, Thursday, Lordship, not Wednesday, Lordship." I conclude the request, Lordship.
Thursday, too many matters are there. Wednesday, we are relatively free, therefore.
But I have difficulties and the paper is this on court regarding the jurisdiction of the plan. Simply that is ongoing jurisdiction. Thank you. Settle this matters.
All right. Thursday.
Thank you, Mr. Chair.
Done? Okay. Wednesday, some matters are fixed. Tomorrow, one matter. All right.
That's.
Tell us, sir,